Good afternoon. The first item of business this afternoon is Stage 3 proceedings on the Vicitims-and-Witnesses Scotland Bill. In dealing with the amendments, members should have the bill as amended at Stage 2, that is SP Bill 23A. The marshalled list, that is SP Bill 23A-ML, and the groupings, that is SP Bill 23A to G. The division bell will sound and proceedings will be suspended for 5 minutes for the first division of the afternoon. The period of voting for the first division will be 30 seconds. Thereafter, I will allow a voting period of 1 minute for the first division after a debate. Members who wish to speak in the debate on any group of amendments should press the request to speak buttons as soon as possible after I call that group. Members should now refer to the marshalled list of amendments. The first group is definition of victim. I call Amendment 25 in the name of Margaret Mitchell in a group of its own. Margaret Mitchell to move and speak to Amendment 25.
Very much, Presiding Officer. The bill confers a whole range of rights on victims, yet the legislation fails to provide a definition of the term victim. Amendment 25 reflects the Justice Committee's Stage 1 report, which recommended the Scottish Government give full consideration to including a definition of victim on the face of the bill. I tabled a similar amendment at Stage 2. In response, the Cabinet Secretary said he was open to including a definition, but identified some areas where the Stage 2 amendment might benefit from clarification. This was helpful. In response to the Cabinet Secretary's comments, I have redrafted this amendment in a number of ways. So it now makes clear that when referring to a victim of an alleged crime, i.e. one that has not yet been proved in court, the use of the term victim does not prejudice the presumption of innocence. The use of the word alleged in the definition avoids the risk that referring to victims in cases before a trial or before a conviction could prejudice the justice process. The definition now refers to offences against property, both tangible and intangible property, and it extends the definition of a victim to prescribed relatives, but only in cases where the relative has died as a result of a crime. The Cabinet Secretary also expressed concern that the amendment was not future-proofed because the nature of crime and victims might change. But in reality, no legislation can consider and be drafted to cover every single eventuality. As with any piece of legislation, if changes are necessary, then further amendment could be made. The important point, however, is that by linking the definition to offences, it will automatically apply to victims as and when the nature of crime changes and new offences are legislated for. And the amendment is intended to cover both natural persons and legal entities in 3 sets of circumstances. The first, cases in which the person has a crime committed directly against them. Secondly, where a relative or dependent of that person suffers harm as a result of a crime committed against that person. And finally, cases in which a person suffers as a result of intervening to help another person against whom a crime is being committed. Harm is defined in such a way so as to cover physical and emotional harm, economic loss and damage to property. Presiding Officer, it appears to me strange that a bill conferring a range of rights on victims of crime does not include a definition of the term. The inclusion of a clear definition will assist in providing clarity for individuals in what may be traumatic circumstances, therefore avoiding further distress and anxiety. There is little point in seeking to make things easier for victims if we are unclear about who victims are. A definition would also assist the police, the Crown and the Court Service in determining and complying with their duties and obligations under the provisions of the bill. This amendment is deemed necessary by the Law Society of Scotland, who emphasised that as far back as Stage 1, that a clear definition will be crucial if the bill is to deliver on its promise to place victims' interests at the heart of ongoing improvements to the Scottish justice system. This, coupled with the fact that the Cabinet Secretary's helpful comments at stage 2 have been incorporated in the new definition, will, I hope, mean that the Scottish Government feels able to support this amendment.
I'm going to call Rod Campbell, followed by Elaine Murray. I'd be grateful if you could keep it as brief as possible, Mr Campbell.
Thank you, Presiding Officer. Well, it's true that the committee drew attention to the fact that the Criminal Procedure Scotland Act 1995 does not use the term victim in relation to matters which apply pre-conviction, using the term complainer. Nevertheless, for the purposes of this Act, I think it's appropriate not to be too prescriptive. Moreover, although the amendment has victim as a person who has or could have suffered harm, harm is defined including loss or damage to property, the rest of the section still talks about offences against the person, implying, at least to me, that where someone has suffered damage to property alone, he would not be a victim. In my view, therefore, the amendment is defectively drafted and should be rejected.
Elaine Murray.
Thank you, Presiding Officer. I too would have difficulty in supporting this amendment as it stands. I said at stage 2 I thought that any definition would be better made by regulation rather than actually on the face of the bill to give it more flexibility. But I also am concerned that this definition is actually rather tight. For example, a person prescribed to be the relative of a person who has died as a victim. However, it could well be argued that somebody who is a partner of somebody who has been raped is also a victim in some senses. And I think actually the definition here is too tight, and I don't feel that we are able to support it.
Thank you. Cabinet Secretary.
Amendment 25, in the name of Margaret Mitchell, would insert an overarching definition of victim into the bill. This amendment is a revised version of an amendment lodged at stage 2, and I welcome the evident consideration given by Margaret Mitchell to the points raised last month. That said, I remain of the view that by attempting to insert an overarching definition of such a clearly understood term, we significantly complicate matters and risk inadvertently excluding individuals who should benefit from the proposals in the bill, or including those who would not fall into any reasonable interpretation of victim. After all, as I have argued throughout the passage of this bill, the word victim is used and understood without definition by justice organisations and victim support organisations across Scotland. In relation to concerns around the word victim negatively impacting the presumption of innocence, I am still of the view that by providing clarity in the context of individual sections, no assumption could be made that the accused is guilty. The relevant sections in the bill will refer, for example, to a person who is or appears to be the victim of an offence, or to circumstances where an offence is alleged to have been committed against the person, with the reference tailored to the context. Furthermore, the presumption of innocence is a right of the accused in every criminal case which is enshrined in Article 6(2) of the European Convention on Human Rights, and there are no circumstances in which this right can be departed from. I also note that Amendment 25 has no consequential amendments. This means that, should it be agreed, it will sit alongside the section-specific definitions of victim in the bill, including the power for the Scottish Ministers to prescribe relatives of victims in certain sections. This, to my mind, will cause uncertainty and confusion. While there has clearly been an attempt to deal with some of the concerns raised about the amendment lodged at stage 2, there are still similar concerns with this amendment. There is still an implication that offences against property are not covered, despite the inclusion of damage to property as a form of harm in subsection 2. In terms of subsection 1A of the amendment, a person can only be considered a victim where the person has suffered harm because an offence has or is alleged to have been committed against the person. There is no mention of offences against property. For these reasons, I consider it better to qualify and explain the use of the term only where necessary, and to make it applicable to the circumstances as in the bill at present. And I invite Margaret Mitchell to withdraw Amendment 25.
Ms Mitchell, to wind up, and could you indicate whether you wish to press the amendment or withdraw?
Thank you, Presiding Officer. I've listened carefully to the points, but there is a point of principle here. It seems to me that including the definition of victim in the bill would be helpful to the very people that it serves to address and help, and that's the victims itself. There's been a number of areas of concern raised, and I think if you're intent on finding fault, then you will do. Nothing that's been said couldn't be rectified, and for that reason, Presiding Officer, I'll move the bill. I'll move the amendment, sorry. The
question is that amendment number 25 be agreed to. Are we all agreed? The division bell will now sound, as this is the first division of this afternoon, and I intend to suspend for 5 minutes. We now proceed with the division on amendment number 25. This is a 32nd division. Members should cast their votes now. The result of the vote on amendment number 25 is as follows: yes 13, no 96. There were no abstentions. The amendment is therefore not agreed to. We move to Group 2, Principal Standards of Service and Provision of Information Consideration of Children. I call amendment number 1 in the name of Eileen Murray, grouped with amendments 2, 26, 3, 27 and 7. Eileen Murray to move amendment 1 and to speak to all the other amendments in the group. Ms Murray.
Thank you, Presiding Officer, and I'll begin by moving Amendment 1 in case I forget later. Amendments 1 and 2 aim to ensure the specific needs, wishes and interests of children are taken into account by those persons required to fulfil the functions set out in Section 1. While much has improved in the experience of children in the criminal justice system as victims and witnesses, and there is significant good practices, cases still arise where children and young people and their families say that the experience of the court case traumatised them all over again. This could be avoided by simply asking children and young people how best to communicate with them and where they would like to meet. The lack of active involvement of children and young people in selecting the most appropriate special measures for them is commonplace, and even when it does happen, often not enough time is given to enable a child victim or witness to give an informed view of what might work best for them. One key area of concern is the provision of information. Evidence shows that over 60% of people in the youth justice estate have difficulties with speech, language or communication. This makes it even more important for information to be made accessible. There is currently no requirement on anyone involved in criminal proceedings to communicate with children and young people in formats and ways which best suit their needs. This might include sending text messages about the date of a trial, sending out a leaflet or emailing them a link to a video about going to court, and not just sending the person a lot of written material. The purpose of Amendment 3 is to require that, when setting and publishing standards in respect to victims and witnesses who are children, this must be done in such a way as the welfare of the child is of paramount consideration. Many child victims and witnesses complain about the long waits for trial, often upwards of 12 months, and in some cases even 2 years and more, a large part of a child's life characterised by waiting and uncertainty. Children do not know if their case will be in a few weeks or a few months. Court dates are often set and then cancelled at the last minute, and this causes disruption and a protracted wait. The test of a child's welfare as being of paramount consideration already exists in Scots law through Section 16 of the Children of Scotland Act 1995. Clearly, the welfare of a child in any case needs to be balanced with the other tests, and in particular with the interests of the accused and those of justice generally. Guidance already exists on this matter to be applied in criminal proceedings where children are involved. This amendment is proportionate and necessary to ensure that the welfare test which already applies to social work and other agencies working with vulnerable children also applies to justice authorities. Amendments 26 and 27 define the meaning of child in the relevant sections. During Stage 2, the Cabinet Secretary expressed the view that specific reference to the needs of child witnesses should not be contained either in the general principles or indeed in the standards of service. I have therefore also suggested an alternative amendment, number 7, which introduces similar provisions in a separate section after Section 2A. I have introduced both sets of amendments for Parliament's consideration this afternoon. In the week when this Parliament has paid tribute to Nelson Mandela, may I provide another quote from him, and that is that there can be no keener revelation of a society's soul than the way in which it treats its children. Through this bill's passage, we have heard of some shocking experiences of children in our criminal justice system. The 2004 Vulnerable Witnesses Act has made a significant difference, and the enactment of this bill and these principles will also make a difference, but we also seek to improve the practice. This amendment, as the previous two, seeks to provide for the needs, interests and wishes for child victims and witnesses through guidance on how to fulfil duties under Sections 1 and Sections 2 in particular. It was argued by the Justice Secretary at Stage 2 that this bill aims to have universal application, and to single out any specific group would be inappropriate. But children are special, and required to be treated specially in our criminal justice system. Had the Justice Secretary's argument held sway, we wouldn't even have had the 2004 Act, never mind many of the excellent measures being brought into law today. This amendment seeks to ensure that the legal duties in this Act are given effect through guidance that tries to take a more child-centred approach. That does fit in with other Scottish ministerial priorities in other areas of policy, and we should make it do so in the criminal justice system as well.
Cabinet Secretary.
Section 1 of the bill sets out a number of general principles which are deliberately both high-level and aspirational and are intended to inform the creation of standards of service under Section 2 of the bill. The intention behind including a section on general principles was to set out the underlying aim of the bill and for the justice system as a whole, and ensure a level of consistency when justice agencies are considering how they interact with victims and witnesses. Amendments 1, 2 and 26 in the name of Elaine Murray are identical to amendments lodged at Stage 2. As I said then, I would expect the bodies listed to consider the needs, rights and wishes of children in the same way I would expect them to consider the needs, rights and wishes of all other victims and witnesses involved in criminal proceedings. My views on this have not changed. I also raised the question at Stage 2 that if we were to single out child victims and witnesses, as the amendments by Elaine Murray propose, should we not also include persons with a mental or physical disability, older persons, and the list goes on? And I think the point remains valid. I would simply reiterate that while I absolutely agree that organisations should take into consideration the requirements of children, I remain of the view that the general principles should be precisely that, general and equally applicable to all groups of victims and witnesses who come into contact with the criminal justice system. Section 2 of the bill requires various criminal justice organisations to set and publish standards of service for victims and witnesses. Amendment 3, in the name of Elaine Murray, would put a duty on a person setting and publishing standards under Section 2 insofar as the standards could relate to a child, to do so in such a way that the welfare of the child is of paramount consideration. This is identical to an amendment lodged by the member at Stage 2. Amendment 27 is consequential to Amendment 3. As I said previously, I would welcome Elaine Murray's commitment to child victims and witnesses. However, as with the general principles, this is simply unnecessary. I would expect the body setting standards to give due consideration to children as they would to any other group. And similarly, if we were to single out child victims and witnesses, should we not also include other groups of victims and witnesses? The list could be considerable. In relation to Amendment 7, I do not see any additional benefit from placing an obligation on the organisations listed in Section 2.2 of the bill to prepare and publish guidance as to how they will consider the needs, rights and wishes of children when, having regard to the general principles, setting their standards of service and providing information. Surely, it's better to let these organisations just get on and set their standards, which will no doubt reference these matters with respect to all victims and witnesses. I believe that putting a duty on these organisations to prepare and lay such guidance before Parliament, which would require to be done before any standards of service are prepared and published, would inevitably slow down the setting of standards and remove the flexibility of organisations to change these quickly in light of experience. In summary, while I appreciate the intention behind the amendments in this group, I think they are unnecessary, and I therefore invite Elaine Murray to withdraw Amendment 1 and not to move Amendments 2, 26, 3, 27 and 7.
I call on Elaine Murray to wind up, and could you indicate whether you are pressing your amendment number 1 or withdrawing it?
Indeed. Presiding Officer, children against whom horrific offences have been committed are required to engage with a system designed by and for adults in order to see justice done. They are amongst the most vulnerable children in our society, and they deserve to be given the support they need to give their evidence and to participate effectively in the process, and in a way which minimises the impact of that engagement. The court process can be confusing and intimidating to adults, never mind to children. And it is essential that consideration is given to the most appropriate way to provide information to a child victim, whether that be orally in writing or other forms of communication. A child victim or witness must be empowered to participate as fully as possible and to understand the process and procedures he or she will be exposed to during the progress of investigation and trial. Our courts are adversarial and the process is combative, where children who may well already be traumatised by the crime witnessed by them or perpetrated against them are involved in the court process. Their welfare must be given the highest priority. Amendments 1, 2 and 3, with the definitions in 26 and 27, remain my preference. I feel that these are the most appropriate parts of the bill to enshrine these rights of child witnesses and victims. However, as the Cabinet Secretary continues to believe they are not. If those amendments are defeated, I shall be pressing Amendment 7 later on, and I continue to move Amendment 1.
The question is, Amendment number 1 be agreed to? Are we all agreed? We are not agreed. There will be a division. This is a 1-minute division. The result of the vote on Amendment number 1 is as follows. Yes, 49. No, 62. There were no abstentions. The amendment is therefore not agreed to. I now call Amendment number 2 in the name of Elaine Murray, already debated with Amendment number 1. Elaine Murray, to move or not move?
Moved.
Sorry. The question is, Amendment number 2 be agreed to? Are we all agreed? We are not agreed. There will be a division. The result of the vote on Amendment number 2 is as follows. Yes, 49. No, 62. There were no abstentions. The amendment is therefore not agreed to. I call Amendment number 3 in the name of Elaine Murray, I call Amendment 26 in the name of Elaine Murray, already debated with Amendment 1. Elaine Murray, to move or not move?
Not moved.
Does any member have any objection to it being withdrawn? No. Okay. I now call Amendment number 3 in the name of Elaine Murray, already debated with Amendment number 1. Elaine Murray, to move or not move?
Moved.
The question is, Amendment 3 be agreed to? Are we all agreed? There will be a division. Please cast your votes now. The result of the vote on Amendment number 3 is as follows. Yes, 49. No, 62. There were no abstentions. The amendment is therefore not agreed to. I now call Amendment number 27 in the name of Elaine Murray, which is already debated with Amendment number 1. Elaine Murray, to move or not move?
Not moved.
The amendment is not moved. The question is Amendment... Sorry? I now call Amendment number 4 in the name of Elaine Murray, grouped with Amendments 5 and 6. Elaine Murray, to move Amendment 4 and speak to all amendments in the group. Elaine Murray.
Thank you, Presiding Officer. The Cabinet Secretary introduced an amendment at Stage 2, introducing Section 2A into the bill, which required annual publication of a report with assessment of whether standards have been met, a forward look regarding how they might be met in the year ahead, with the ability of ministers to prescribe information by way of a negative instrument. I introduced a similar amendment at the same time at stage 2. Mr McCaskill's amendment made, in our opinion, a serious omission, which was not made in my own amendment, in not requiring consultation as far as reasonably practical with victims and witnesses in the preparation of the report. And Amendments 4, 5 and 6 seek to rectify this omission. Amendment 4 requires those persons in Section 2 in making a report on the meeting of standards to consult, as far as is reasonably practical, with victims and witnesses. This was the principal difference between the Cabinet Secretary's successful amendment and mine in Stage 2. Amendment 5 requires Scottish ministers to consult the persons required to set and publish when making regulations which prescribe the information which must be contained in reports. And Amendment 6 enables standards to be revised to meet the needs of victims and witnesses and requires publication of those revised standards. These amendments seek to ensure that victims and witnesses are and continue to be involved in all stages of the development of standards and reporting on how these standards are met. After all, victims and witnesses are supposed to be the central concern of this legislation, and omitting them from this process seems to fly in the face of the intention of the legislation.
Cabinet Secretary.
Section 2 of the bill requires various criminal justice organisations to set and publish standards of service for victims and witnesses. As a result of a government amendment agreed unanimously by the Justice Committee at Stage 2, each of the named organisations in Section 2 will be required to consult with all of the others and with those with a significant interest before publishing their standards of service. This will ensure a level of consistency in approach to the standards, while still allowing for organisation-specific standards to be developed relating to the type of service a particular organisation provides. The Justice Committee also agreed to a government amendment at Stage 2, placing a duty on the named organisations to publish a report assessing how their standards have been met, how they intend to continue to meet them, any modification made to the standards during the reporting period, and any modification they propose to make during the next year. This reporting will not only ensure that the criminal justice organisations reflect on how they have met the standards during the period of the report, but also to think ahead as to how they intend to meet the standards in the future. Amendments 4, 5 and 6, in the name of Elaine Murray, are very similar to elements within the member's alternative proposal for a reporting requirement at Stage 2. While I do appreciate the intention behind these amendments, I consider them to be unnecessary. With regard to Amendment 4, I find it difficult to imagine how the named organisations could prepare reports on how they have met their standards of service in relation to victims and witnesses without taking into consideration the views of victims and witnesses who have come into contact with the organisation. This does not need to be provided for in legislation. Amendment 5 would require the Scottish Ministers to consult with the named persons in Section 2.2 prior to adding to the list of information to be covered in reports on standards of service. Whilst it is clearly sensible to discuss any such changes with those to be affected by any regulations, I am not persuaded that a statutory duty to consult is necessary. Such consultation would take place as a matter of course. Furthermore, the drafting of this amendment is such that the Scottish Ministers would be required to consult with themselves, as they are amongst the persons named in Section 2.2. Amendment 6 provides that the persons named in Section 2 can revise their standards of service so as to meet the needs of victims and witnesses following a report, and obliges them to publish any revised standards. This is simply unnecessary. The organisations in question are free to revise their standards at any time under Section 2, as Section 7.2 of the Interpretation and Legislative Reform Scotland Act 2010 provides that a duty imposed by an Act of the Scottish Parliament may be performed from time to time. Indeed, Section 2A, 3, C and D of the Bill specifically require the organisations in question to list any modifications made to their standards during the reporting year and any modification which the organisation proposes to make in the following year. In any event, I would expect those organisations in question to be reviewing their standards regularly to ensure they remain fit for purpose. In addition, these named organisations are required to publish their standards of service in terms of Section 2.1, and this would also apply to any modifications made to the standards. No explicit provision is necessary to achieve these aims. They are already provided for. And I would therefore invite Elaine Murray to withdraw Amendment 4 and not move Amendments 5 and 6.
Elaine Murray, to wind up, to indicate whether you are pressing or
I'll solely wind up by
4.
moving the amendment, which I forgot to do for my introductory speech.
You are moving it?
Yeah, I'll move it.
Thank you. In that case, the question is that Amendment 4 be agreed to. Are we all agreed? Then we have a division. This division will be 1 minute. The result of the vote on Amendment number 4 is as follows. Yes, 46. No, 63. There were no abstentions. The amendment is therefore not agreed to. I now call Amendment number 5 in the name of Elaine Murray, already debated with Amendment number 4. Elaine Murray to move or not move?
Moved.
The question is that Amendment 5 be agreed to. Are we all agreed? We have a division. If you could vote now. The result of the vote on Amendment number 5 is as follows. Yes, 47. No, 63. There were no abstentions. The amendment is therefore not agreed to. I now call Amendment number 6 in the name of Elaine Murray, already debated with Amendment 4. Elaine Murray to move or not move?
Moved.
The question is that Amendment 6 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division. Members should cast their votes now. The result of the vote on Amendment number 6 is as follows. Yes, 47. No, 63. There were no abstentions. The amendment is therefore not agreed to. I now call Amendment number 7 in the name of Elaine Murray, already debated with Amendment number 1. Elaine Murray to move or not move? Moved. The question is that Amendment 7 be agreed to. Are we all agreed? We are not agreed. There is a division. Members should cast their votes now. The result of the vote on Amendment number 7 is as follows. Yes, 48. No, 62. There were no abstentions. The amendment is therefore not agreed to. We now move to Group 4, Provision of Information and Support for Witnesses and Victims. Call Amendment 28 in the name of Margaret Mitchell. Group with Amendments 21 and 24. Margaret Mitchell to move Amendment number 28 and speak to all other amendments in the group. And Graham Pearson to speak to Amendment 21 and other amendments in the group. Margaret Mitchell.
Thank you, Presiding Officer. When scrutinising the bill, the Justice Committee heard that communication between justice organisations was not as good as it could be. During Stage 2, I lodged a similar amendment, and the Cabinet Secretary agreed that there was room for improvement in terms of justice organisations working together. The committee heard from the Scottish Police Federation that all partners in the criminal justice system would accept that we have been poor at keeping victims and witnesses informed as to the progress of cases in which they are involved. Victims also said that correspondence was often complex and difficult to understand, particularly when they may already be confused and distressed in the aftermath of a crime. Worryingly and astonishingly, David McKenna of Victim Support Scotland told the committee that victims had to tell their story around 16 times to various agencies, which clearly should not be necessary and can only add to victims' distress. This amendment seeks, therefore, to tackle this problem for the first time in legislation, with a requirement for the Lord Advocate, Police Scotland and the Scottish Court Service to work together on the provision of information to victims. It would crucially require all victims and witnesses to be offered a single point of contact to help them through the justice process. The amendment provides for properly trained individuals to give much-needed support for victims who are currently not treated with the compassion nor given the time they deserve in all cases. To have someone who can answer questions and offer support about what can be a very daunting process for witnesses does not seem to me a particularly arduous requirement and should really be offered as a bare minimum. If the Cabinet Secretary is really serious that things should be made easier for victims, then this amendment is necessary. Justice organisations may be considering or discussing how they can work together, but legislating to require them to do so will certainly focus their minds and make sure that this is a priority. Furthermore, despite the Cabinet Secretary consistently talking about improvements for victims over many years now, little has been achieved. The bill provides us with the opportunity to make sure that the criminal justice system takes meaningful steps to coordinate how information is provided to victims now. On the single point of contact, the Cabinet Secretary told the committee at Stage 2 that the Scottish Government was working on an online information hub to provide easier access for victims and witnesses to case-specific information. But as yet, no details of this online hub are available. Furthermore, the fact that it is an online hub means that it already excludes a large chunk of individuals who don't have access or knowledge of the internet and puts the onus on victims to find out information. Amendments 21 and 24 in the name of Graham Pearson appear sensible measures which will similarly improve the provision of information to victims and I believe complement Amendment 28 in my name, which I now move.
Graham Pearce to speak to Amendment number 1 and other amendments in the group.
Thank you, Presiding Officer. First of all, can I acknowledge the amendment in Margaret Mitchell's part and indicate my support for the amendment. Throughout the evidence that we heard in Justice Committee, it became very apparent that there were two worlds out there. There was a world of victims who came and spoke to the committee in deeply moving fashion of the way they perceived services were provided on their behalf as they made their journey through the justice system. I don't think there will be a member here in the chamber who hasn't spoken to a witness or victim who has shadowed the very opinions that were given during the evidence session that we heard at Justice Committee. And it does demand that we offer some response. And Amendment 28 will push services in that direction in terms of coordination of support and providing a single point of contact. The Labour Party had at one stage provided that a Commissioner would be a way to deliver on this, but it soon became apparent there was no appetite for such a post. But the notion of a single point of contact or a case companion, whatever nomenclature one would want to use, is and would be a significant improvement on current arrangements. The notion that was offered to us by the victims indicated that they felt like a parcel being passed through the system. And without taking too much time of this debate, a lady travelled from the north-east of Scotland in order to meet me yesterday because she knew of this debate, and she passed me a letter that she'd sent into the authorities. I was disappointed with the responses. It did not address the issues I raised in my letter. The vagaries of the criminal justice system are unbelievably difficult to understand for victims who have lost a loved one who died as a result of a criminal act. I found it particularly galling to read about prisoners' rehabilitation and the support available there, when indeed it was the needs of victims that she tried to address. So I think that Amendment 28 goes a long way to dealing with these issues. Amendment 21 ensures that those who would receive the information in respect of a release had intimated that they would want that information passed to them, and that they would receive the intimation in a form that they would reasonably require, because very often it's an official letter which is written in official language which is difficult to understand. Amendment 24, guidance and provision of information to victims in court proceedings and solemn cases. Victims and witnesses are still going to our courts and being led into a situation with no guidance and support, and that leads to them not understanding what's happening and very often confronting the very accused that they're there to deal with in terms of their processes. So I would commend both these amendments and I would move for consideration. Thank you.
Members will note that we've passed the agreed time limit for the debate on this group to finish. I am exercising my power under Rule 984A to allow the debate on the group to continue beyond the limit in order to avoid the debate being unreasonably curtailed. Cabinet Secretary.
As with a similar amendment lodged by Margaret Mitchell at stage 2, I welcome the underlying principles behind Amendment 28. I think members would agree that encouraging justice organisations to work more closely together to improve the experience of victims and witnesses is a laudable aim. However, I can only reiterate that I do not consider that this requires primary legislation. For the benefit of those who did not follow proceedings at stage 2, I would note again that we are already participating in discussions between all justice organisations to explore how they can work more effectively together and deliver a more joined-up experience for victims. I would see the improvement of communications as being part of that wider work, and in particular, I would expect it to be something that is considered when justice organisations are developing their standards of service under Section 2 of the Bill, during which process they will require to consult with each other and with relevant stakeholders. In relation to the proposal for a single point of contact, I am still of the view that this does not require a statutory basis. We are currently looking at the feasibility of establishing an online information hub to provide easier access for victims and witnesses to case-specific information. And while establishing such a system will not happen overnight, given the complexities of sharing potentially sensitive information between various different organisations, I do think that this will bring great benefits. And in the meantime, victims and witnesses will have new rights to access certain information directly from the Crown Office, Police Scotland and the Scottish Court Service under Section 3 of the Bill. And turning to Graham Pearson's Amendment 21, while this is clearly well-intentioned, I fear it could cause significant practical issues. In certain criminal cases, victims have the right under Section 16 of the Criminal Justice Scotland Act 2003 to receive information about the release of an offender and other relevant details. In practice, this is provided by the Scottish Prison Service through the Victim Notification Scheme. Section 23 of the Bill removes the list of prescribed offences in relation to VNS so that victims of all offences will potentially be eligible. Furthermore, I have already expressed my intention to lower the sentence threshold for VNS. These changes are likely to increase the numbers of victims registered with VNS and the administrative burden on SPS. Whilst a phone call may be viewed as a reasonable method of communication, it would be a significant burden on any organisation if a high volume of correspondence suddenly had to be dealt with by phone or potentially through a face-to-face meeting, if requested. Moreover, the obligation to seek the views of all victims registered in the VNS before communicating with them would have significant resource implications for SPS in delivering the scheme. I believe that a more appropriate way of improving communication with victims is not through an impractical statutory obligation, but through better training and guidance for those involved. Turning now to Amendment 24, also in the name of Graham Pearson, I consider this to be completely unnecessary. The bill already establishes in statute essential rights and obligations which will ensure that victims and witnesses have access to important information about criminal proceedings, including in relation to the most serious cases. I therefore cannot see what is to be gained in the Scottish Ministers issuing guidance on the matter to the Scottish Court Service, specifically in relation to solemn proceedings. Furthermore, in the unlikely event that any guidance was necessary, no specific provision is required. Under Section 69 of the Judiciary and Courts Scotland Act 2008, the Scottish Ministers can already issue guidance to the Scottish Court Service, to which the Scottish Court Service must have regard in the carrying out of its functions. This amendment therefore replicates a provision which is already laid out in statute. While I cannot support Graham Pearson's amendment, I restate now the commitment I made to him at Stage 2, that the Scottish Government will continue to work with our justice partners in this area to ensure that any information provided to victims is clear and easy to understand. And in summary, whilst I support the broad principles behind our Amendment 28, I consider it unnecessary and invite Margaret Mitchell to withdraw it, and I also urge Graham Pearson not to move Amendments 21 and 24.
I call on Margaret Mitchell to wind up and to place or withdraw her amendment. I'd be grateful if you could be brief.
Okay, Presiding Officer, thank you. It seems that the much vaunted but to date phantom online hub, which the Cabinet Secretary keeps telling us about, is no further forward. And the fact of the matter is, Presiding Officer, the guidance to which he refers isn't working. Without primary legislation, then victims will have to continue to give their story 16 times over, and that's frankly unacceptable. This amendment would require it to be a priority that a single point of contact was established to avoid that happening. On that basis, I press the amendment.
Question is, amendment number 28 be agreed? Are we all agreed? We are not agreed. We move to a vote. Members should cast their votes now. So 1 minute. The result of the vote on amendment number 28 is as follows. Yes, 46. No, 63. There were no abstentions. The amendment is therefore not agreed to. Move to Group 5, Restorative Justice. I call Amendment 8 in the name of the Cabinet Secretary. It's in a group of its own. Cabinet Secretary to move to and speak to the amendment.
At Stage 2, the Justice Committee accepted an amendment relating to restorative justice, which was put forward by Alison McInnes. That amendment, now Section 2C of the bill, puts a duty on the Scottish Ministers to make provision by regulations for the referral of victims and offenders or alleged offenders to restorative justice processes. In principle, this is something I welcome. I appreciate why Alison McInnes brought her amendment forward, and I agree that more consideration should be given to the potential benefits of restorative justice to victims. We already know that it can be useful in relation to youth justice in particular. However, I do have some concerns that Section 2C, as it stands, could be interpreted as essentially giving individuals a statutory right to access such services, and I think that this would be premature. Detailed consideration would need to be given to the nature and effectiveness of the services to be offered and to the potential costs, which clearly cannot be ignored in the current financial situation. By all means.
Alison McInnes.
Thank you, and I thank the Cabinet Secretary for meeting with me to explore the best way forward on this issue. Can he perhaps reassure me that the timetable for the first set of guidance that he'll take forward, perhaps in relation to youth justice, will be in the near future? And will he commit to establishing a short-life working group comprised of relevant stakeholders to help him develop the guidance?
Cabinet Secretary.
Well, I'm happy to work with all stakeholders and I'm happy to meet with the member to discuss this further. I think what we are keen to do is to build upon what we already know and why Alison McInnes moved her amendment, that we do know that it can have outstanding success at youth level. What we have to do is to make sure that we build upon it and have a solid base. So rather than commit to a short-life working group, I'm happy to meet with her, and I'm sure all the other stakeholders would equally commit to that. What I can say is that given the voluntary and case-specific nature of any restorative justice services, there are compelling reasons for adopting a more flexible approach than would be possible through a statutory scheme. In particular, it would be very difficult to establish definitive circumstances in which referral would be appropriate, reflecting the very personal and specific circumstances of each case and giving due consideration to issues such as the potential risk to and safety of victims. Similar points have been raised with me by the victim supports groups such as Victim Support Scotland and Scottish Women's Aid, who agree that further consideration and a more flexible, victim-focused approach is required. My Amendment 8, which is supported by both Victim Support Scotland and Scottish Women's Aid, seeks to allow for a more measured approach to be taken. It would replace the current duty in Section 2C to make regulations with an ability for the Scottish Ministers to issue guidance relating to the referral of individuals to and the provisions of restorative justice services. This will allow clear guidelines to be established, taking into consideration any obligations in the recent EU directive on victims' rights, while retaining more flexibility than would be possible if such detail were set out by statutory instrument. A duty may also be placed on persons who will be specified by order to have regard to this guidance. This order-making power could be used to place such a duty on those persons referring individuals to or providing restorative justice services. If passed today, I would intend to issue guidance with a particular focus on the appropriate use of this measure and on the safeguards which would be in place to ensure that victims are protected if they choose to participate in any available restorative justice services, as rightly highlighted by Alison McInnes at stage 2. Before issuing guidance, however, it is clear that we will need to discuss what specific matters should be covered with those who have detailed knowledge and experience, and have already signalled to SACRO, Victim Support Scotland, Scottish Women's Aid and others that we will be seeking their input on this, and I look forward to constructive discussions next year. In summary, I can give Alison McInnes an assurance that this amendment is not intended to negate or weaken Section 2C of the bill, but rather to adapt it into a more practical form, and I am happy to continue discussions with her at a later date. I move Amendment 8.
Alison McInnes, briefly, please.
Thank you very much. I welcome the fact that the Cabinet Secretary has sought to respect the will of the committee and that he's chosen to revise the provisions referring to restorative justice rather than remove them. And I know that organisations such as SACRO are appreciative of the retention. Amendment 8 does, as the Cabinet Secretary says, soften the provisions significantly, but I understand that the Cabinet Secretary believes that these changes will give the system greater flexibility. I came to the Chamber seeking reassurances that should Parliament agree this amendment, the Cabinet Secretary will proceed to establish guidance. I've heard from the Cabinet Secretary today those assurances, and therefore I welcome that, and I welcome the opportunity to meet him again in due course. Thank you.
Cabinet Secretary to wind up.
I'm happy to accept Alison McInnes's points, and I'm happy to meet with her and discuss her. I think we share a common view that restorative justice has worked, does good service, but we've got to make sure that it works for all, because there are some for whom it would be counterproductive.
The question is that Amendment 8 be agreed to. Are we all agreed? Yes. The Parliament is agreed. We move to Group 6, Minor and Technical. I call Amendment 9 in the name of the Cabinet Secretary, grouped with amendments number 10, 11, 13, 14, 15, 16 and 20. Cabinet Secretary, if you could move Amendment 9 and speak to all other amendments in the group.
Section 3 of the bill gives victims and witnesses the right to access certain information about their case from various bodies and reflects the requirements of Article 6 of the EU Victims' Rights Directive. Following introduction of the bill, the Office of the Advocate General raised some concerns that the obligation in Section 3 could, in rare cases, lead to the disclosure of confidential information supplied by the UK Government. There is already an exception to the duty to provide information in Section 3, whereby information does not have to be disclosed if the qualifying person considers that disclosure would be inappropriate. I consider the level of discretion that the wording of this exemption provides to be essential, as it allows the Police, Crown Office and Court Service to exercise their professional judgment in response to the individual circumstances of the case. However, I also recognise that it gives the qualifying person discretion as to whether or not to disclose confidential information supplied by the UK Government, as there is no obligation to withhold this confidential information. My Amendment 9 therefore obliges qualifying persons to refuse a request relating to a decision not to investigate, a decision to end an investigation, or a decision not to prosecute the alleged offender, insofar as complying with the request would involve the disclosure of information supplied by the UK Government or a Minister of the Crown and held in confidence. The amendment is intended to ensure, for example, that the bodies named in Section 3(5) of the Bill are obliged not to disclose information received from the UK Government in relation to national security and held in confidence. I do not expect this exception to be widely applicable, but I hope members will agree that we should do all we can to avoid inadvertently revealing confidential information which could prejudice serious investigations. Amendments 10, 13 and 14 are minor technical amendments to correct a reference to certain offences in the Sexual Offences Act 2003. Amendments 11 and 15 are also minor technical amendments and substitute the references inverted commas, to an offence consisting of domestic abuse, close inverted commas, in sections 5(d) and 6(a) of the Bill respectively, with, and again I quote, an offence the commission of which involves domestic abuse. The purpose of these amendments is simply to make clear that whilst domestic abuse in itself is not a statutory offence, any offence which contains an element of domestic abuse is covered by the provisions in section 5 and 6 of the Bill. Amendment 16 relates to the process for submitting vulnerable witness notices to the court, containing details of specific measures which are required for vulnerable witnesses. The Crown Office and Procurator Fiscal Service has been examining ways of streamlining this process in order to increase efficiency and lower costs. Amendment 16 will assist in this process. Where a vulnerable witness notice specifies only standard special measures, Amendment 16 removes the requirement for a summary of the witness's views, and where the victim is a child, the views of the witness's parent in relation to the special measures requested to be contained or attached. The party making the vulnerable witness notice will still be required to take account of the views of the witness, but as the court has no discretion as to whether or not to authorise any standard special measure requested, it must grant them. It follows that there is little point in providing the court with a summary of views expressed. In all other cases where the court has a discretion to authorise the use of special measures, the requirement for the court to be informed of any views expressed by the witness or the witness parents will remain. Finally, Amendment 20 is a minor drafting amendment to Section 21 of the Bill to insert the word "or", making it clear that the paragraphs in new Section 253B4 of the Criminal Procedure Scotland Act 1995 are intended as alternatives. I move Amendment 9.
Thank you, Cabinet Secretary. I take it you feel no need to wind up the debate. The question is then that Amendment 9 be agreed to. Are we all agreed? Yes. The Parliament is agreed. I call amendments number 10, 11 and 13, all in the name of the Cabinet Secretary and all previously debated. I invite the Cabinet Secretary to move amendments number 10, 11 and 13 en bloc.
Moved en bloc. Does
any member object? A single question be put on amendments 10, 11 and 13. No member objects. So I intend to take amendments number 10, 11 and 13 en bloc. Are we all agreed? Yes. We are agreed. We now move to Group 7. Evidence in relation to sexual offences, disclosure of information. I call amendment number 12 in the name of Graham Pearson, grouped with amendments number 29, 30 and 31. Mr Pearson, if you could move amendment 12 and speak to all other amendments in the group.
Thank you, Presiding Officer. This group of amendments arise from very significant concerns raised by Rape Crisis, Women's Aid, domestic abuse groups and other associated women's groups, who feel that the application of legislation already in place designed to ensure that the disclosure of sensitive personal information as part of the court procedures would only be done relevant issues, in relevant cases, and in a sensitive and handled fashion. Experience of victims as recorded to the Justice Committee and through the lobbying from these groups has indicated that the current legislation is not applied in a way that has been effective. As far as Amendment 12 is concerned, it's an approach which would indicate the Lord Advocate should prepare and publish guidance about circumstances in which sensitive personal information in relation to a person who is a victim can be used within the public court process, and the other subsections refer to the means by which such guidance could be prepared, produced and disseminated. And I would move that amendment. Margaret Mitchell's amendment at 29, in the event that my own amendment fails, is one that I would also support. It takes a different approach to a similar problem, but in her own amendment, she indicates the need for legal advice being provided to a victim in order that necessary processes could be put in place to protect the interests of that victim in the system. Again, the attached amendments to Margaret Mitchell's proposals set out the means by which that can be delivered, and I have no comment to offer in that regard.
I'm now going to call Margaret Mitchell to speak to Amendment 29 and the other amendments in the root group.
Thank you, Presiding Officer. Amendments 29, 30 and 31 in my name seek to tackle the long-standing vexing problem involving the use of sexual history and character evidence in sexual offence trials. An evaluation commissioned by the Scottish Government and published in 2007 found that far from tightening the use of sexual history and character evidence, legislation introduced by the Scottish Government in 2002 had actually led to an increase in the use of this type of evidence. The key findings of the research make for concerning reading. 72% of trials featured an application to introduce sexual history or character evidence, and only 7% of these applicants were refused. So despite the Cabinet Secretary's assurance that the Crown Office has comprehensive guidance in place to ensure that victims are given a full explanation of exactly why any sensitive information is sought, the fact of the matter is that in practice this guidance is not effective and is failing to protect complainers. Ongoing research carried out by Rape Crisis Scotland on the information being sought makes compelling reading too. Nearly 60% of those who have responded said they felt they had no choice but to provide sensitive information, and 35% said no one explained to them why the information was being looked at. Less than 15% said they were clear why the information was being requested. And the concerns about the inappropriate use of this type of evidence designed to play to the jury's prejudices are well documented. Amendments 29, 30 and 31 reflect some of the points raised at stage 2. Amendment 29 allows independent legal advice to be offered to victims of sexual offences as soon as the police, the Crown or Defence seek to access health or other sensitive records. More often or not, this is when the complainer is at their most vulnerable, which is why independent legal representation at this point is so important, especially as complainers and victims felt as if they had no choice other than to agree to consent. It is therefore the intention that this legal advice will be offered to victims and that some form of financial support will be available for this. The amendment leaves it open for the Scottish Government to set up a dedicated fund for this, if appropriate, and of course it would be open for legal aid to be extended to include independent legal advice, though this would take further amendments. Amendment 30, importantly, allows the Scottish Government to run a pilot to see how independent legal advice works in practice and also to collect much-needed data. Rape Crisis Scotland, have been in touch with the Legal Services Agency, which is Scotland's largest law centre, tackling the unmet legal needs of those in disadvantage. One of the areas where LSA undertakes work is in protecting the rights of refugee and migrant women and children through its Women and Young Persons Department. The proposed pilot would be affiliated to this department and will allocate one specialist solicitor 1 day a week for 6 months in order to provide the following initial advice regarding access to medical sensitive records. The advice can be provided at the premises of the Legal Services Agency or Rape Crisis. During the pilot phase, the specialist solicitor will identify and undertake the following: collation of case outcomes, the cost of providing legal support, evaluation of the pilot from the point of view of its clients and external parties.
I really need to ask you to wind up. You've now had 5 minutes.
And cooperative fiscal. Amendment 31 would require for a report to be published, and these arrangements satisfy that. Presiding Officer, I accept that the use of independent legal advice is uncharted territory, which is why I provided a pilot. And by limiting the pilot to the most serious sexual offences, that of rape, and providing that the pilot can apply to only one High Court location, costs will be minimal. This is a common sense proposal which I hope that the Scottish Government can support.
Thank you. I'm anxious to get some other members in. So the next 3 members, if you could keep it very brief. Malcolm Chisholm, followed by Rod Campbell.
Briefly, I support Graham Pearson's amendment, but also Margaret Mitchell's. And since they may prove to be more controversial, I'll speak briefly about them. I think they may appear to be unusual, but they are dealing with a very unusual circumstance, because what other complainer, what other victim, apart from a rape victim, has all her or his personal and medical details revealed in the court? As we know happens in that case, we've had a report in the last few days from Rape Crisis Scotland which details the kind of information that is routinely and regularly given in Scottish courts in rape cases. For example, one woman said, "My mental health was all I felt was talked about, not being raped." And someone else said that they were put off therapy and counselling because they knew that would be used against them in court. Others, in fact, may not come forward in the first place to complain of what has happened to them because they know that this may happen in court. So I think this is problematic in terms of a right to privacy, but be that as it may, women have no real choice in this situation. Whatever the guidelines say, this information can routinely be used in court, and the least we can do to protect these women and to protect the rights of these women is to ensure that they do have independent legal advice and representation so that their case can be put in this kind of situation.
Thank you, Rod Campbell, followed by Alison McInnes.
Thank you, Presiding Officer. Briefly in relation to Graham Pearson's Amendment 12, I have difficulties in considering that any guidance the Lord Advocate could produce this could be anything other than in a very general sense. I've also got concerns as to whether or not this is placing too much emphasis on the Lord Advocate alone and not taking account of also the interests of the accused in the process. Is this providing the right balance? I think not in relation to that amendment. As far as Margaret Mitchell's amendment is concerned, I've got some sympathy with it, in particular in relation to sexual history applications under sections 274 and 275. Often, this is a very common occurrence. A complainer or victim is confused, takes the view that she should have her lawyer, that she doesn't understand that the Crown is representing the public interest and not her. I think a pilot approach is entirely the wrong way of looking at this, and really we shouldn't have a pilot approach in statutory legislation. So I've got some sympathy with Margaret Mitchell, and I think the government would be wise to kind of update research and information in relation to sexual history applications, but supporting these amendments is not the right way forward.
Alison McInnes.
Thank you. I support all the amendments in this group. It is important that those who are being asked to provide sensitive information, whether it is health, social work or education records, have the opportunity to gain legal advice and representation before doing so. There's no doubt that being required to reveal such information can leave victims feeling exposed, further violated, and their right to confidentiality has been denied. In some, they can feel further victimised. And I am concerned that in some cases this evidence can prove prejudicial. During the course of this bill, I have met with many victims and their stories haunt me. One woman told me that giving evidence was a harrowing experience, psychologically damaging. She was so distressed that the court proceedings were halted by the judge on a number of occasions. No one had explained to her the amount of detail she would have to give about what were appalling acts of sexual violence against her. She was particularly disturbed that she had not been told that her medical records detailing her injuries would be read out in full to the court and to the jury. We need to strive to ensure that such information is only revealed when it is appropriate, and I would therefore welcome additional safeguards in this area and the increased protection for victims of sexual offences that these amendments would provide.
Cabinet Secretary.
Well, I think we all accept that there is an issue, a great deal of sympathy for it. Work is ongoing, and I think, as Rod Campbell correctly said, a pilot in the face of primary legislation is not, I think I'm persuaded, the best approach. Let me turn first to Amendment 12 in the name of Graham Pearson. While I agree that an appropriate and consistent approach should be taken by the Crown Office and Procurator Fiscal Service in seeking access to such information, this amendment is simply unnecessary. The Lord Advocate has already issued guidance, and that's post the statistics mentioned by Margaret Mitchell on the seeking of sensitive information in such cases, which is set out in the publicly available document entitled Policy on Obtaining and Disclosing Sensitive Personal Records in the Investigation and Prosecution of Sexual Crime Cases. Given the range of matters about which the Lord Advocate issues guidance, I would be reluctant to impose a statutory duty in relation to one particular topic, especially one in relation to which guidance already exists. If there are specific matters which are felt to be missing from the existing guidance, I know that Crown Office would be happy to receive and consider any feedback. The amendment is also unnecessary in relation to the disclosure of information about the victim. Disclosure of information which is held by a prosecutor is already provided for in Part 6 of the Criminal Justice and Licensing Scotland Act 2010, and these statutory provisions will clearly take precedence. Turning to Amendments 29, 30 and 31 in the name of Margaret Mitchell, these, as indicated at Stage 2, result in a major innovation in our law. There are currently no rights for victims to have independent legal representation in criminal proceedings, as Rod Campbell was correctly referring to. It's the Crown Act in the public interest, not as a prosecutor, but in the public interest. We are being invited to make a major change in a fashion that's not been fully thought through and which has not been properly explored. The case, I believe, has not as yet been made. It doesn't mean that it can't be made, but it's certainly not been made. Rape Crisis Scotland themselves acknowledge that since the publication of the Crown Office's guidance I mentioned earlier, there has been no additional data collected in relation to the use of medical history or other sensitive information. The Crown Office has offered to work with Rape Crisis Scotland in this respect. In the meantime, acting on the basis of no data would be irresponsible. In addition, it's entirely unclear how these provisions would operate in practice. Margaret Mitchell's amendments would enable victims to appoint a legal representative wherever health or other sensitive information was sought. However, this covers a very broad range of information, much of which is not currently subject to any restrictions in terms of being introduced as evidence. These amendments do not create an application process for the admission of health or other sensitive information, so it's unclear how the process of appointing a legal representative for the victim would commence. The amendments do not provide for the admissibility of this evidence to be debated at an oral hearing, so it's unclear how the submissions about the evidence would be made. If additional hearings were to be arranged, further amendment of the legislation would be required, and that is to say nothing of the attendant delays to the court process, which would have an impact on victims and witnesses and the significant costs that would be involved in arranging these hearings. The amendments also do not provide any guidance for the court or the victim as to when health or other sensitive information would be admissible. For example, there is no requirement that the court must carry out a balancing exercise between the interests of the victim and the proper administration of justice. The scale of the innovation proposed in these amendments is clearly recognised by Margaret Mitchell, given the provisions around carrying out a pilot. However, without a great deal more clarity about how these amendments are to work in practice, I fail to see the benefit of these. Moreover, the provisions for terminating a pilot are defectively drafted, with no provision made for reversing commencement. Regardless of the outcome of the pilot, the provisions would remain in force. Clearly, if information is being sought, then the reason for this should be clearly explained to the victims, but this seems a matter which should be dealt with on a practical basis, rather than requiring advice from a solicitor, and as I have already mentioned, the Crown Office in particular has comprehensive guidance in place to ensure that victims are given a full explanation of exactly why any sensitive information is being asked for. Furthermore, in the event that legal advice is required, current legal aid legislation already makes this available to victims and witnesses through advice and assistance, subject to the usual statutory tests. On the subject of legal aid, I note that Margaret Mitchell's amendment proposes an entirely new fund be established to pay for any advice or representation to alleged victims. Given the complexities involved in setting up a new fund, not to mention the cost and the financial situation, I am not convinced that this would be a particularly sensible approach. I have already met with Rape Crisis about their concerns, as have my officials. We recently arranged a meeting between Rape Crisis and the Scottish Legal Aid Board to explore what additional support might be available within current legal aid arrangements, going beyond what is already available through the Advice and Assistance Scheme. Equally, colleagues in Crown Office have similarly discussed these matters in detail and have indicated a willingness to assist Rape Crisis in exploring how such evidence is used. In summary, I don't believe that a pilot in the face of primary legislation is the best way to go. We do have discussions ongoing between Rape Crisis Scotland and the Scottish Legal Aid Board, and I am happy to commit to that, and they are working together constructively. Equally, I am more than happy to engage further with Rape Crisis Scotland regarding other matters that they have raised with myself and other members. But I think if we are to have a pilot, we should work out the practical details, actually pilot it before we embark on primary legislation. So I have a great deal of sympathy with where members are coming from, but we do have to make sure that we get it right. We are dealing with a situation where we have vulnerable victims. What we don't want to do is to make it worse for them. I therefore invite Graham Pearson to withdraw Amendment 12 and Margaret Mitchell to not move Amendments 29, 30 and 31.
I now call Graham Pearson to wind up and to indicate whether he wishes to press or withdraw Amendment 12. I'd be grateful if you could be as brief as possible, Mr Pearson.
I take the hint, Presiding Officer. I'm sorry to disappoint the Cabinet Secretary, but I won't withdraw. All the words that he's just given us in summation means for women who go through our courts no change. The aspect of this legislation has largely been driven by European legislation which demands differing approaches in member countries, and hence this move forward. It hasn't looked at it from the point of view of victims, and I would hope that members will really consider this issue. It's 10 years it's been at the centre of a problem in our courts, and we need to move now. I move.
Thank you, Mr Pearson. The question is Amendment number 12 be agreed to. Are we all agreed? We are not agreed. We are not agreed. Therefore, there will be a vote. Members should cast their votes now. The result of the vote on Amendment number 12 is as follows. Yes, 49. No, 61. There were no abstentions. The amendment is therefore not agreed to. I now call Amendment 29 in the name of Margaret Mitchell. It's already been debated with Amendment number 12. Margaret Mitchell to move or not move?
Move, Presiding Officer.
The question then is that Amendment number 29 be agreed. Are we all agreed? We are not agreed. We go to a vote. Members should cast their votes now. The result of the vote on amendment number 29 is as follows. Yes, 49. No, 61. There were no abstentions. The amendment is therefore not agreed to. I now call amendment number 30 in the name of Margaret Mitchell, already debated with amendment 12. Margaret Mitchell, to move or not move?
Move, Presiding Officer.
The question is, amendment 30 be agreed to. Are we all agreed? We are not agreed. We move to a vote. Members should cast their votes now. The result of the vote on amendment number 30 is as follows. Yes, 48. No, 61. There were no abstentions. The amendment is therefore not agreed to. I now call amendment number 31 in the name of Margaret Mitchell, already debated with amendment 12. Margaret Mitchell, to move or not move?
Move, Presiding Officer.
The question is, amendment number 31 be agreed to. Are we all agreed? We are not agreed. We move to a vote. Members should cast their votes now. The result of the vote on amendment number 31 as follows. Yes, 49. No, 61. There were no abstentions. The amendment is therefore not agreed to. I now call amendments number 14, 15 and 16, all in the name of the Cabinet Secretary and all previously debated. I invite the Cabinet Secretary to move amendments number 14 to 16 en bloc.
Moved on bloc.
And any member who objects to a single question being put on amendments 14 to 16? There are not. No member objects, so the question is that amendments number 14 to 16 are agreed to. Are we all agreed? We are agreed. As we are nearing the agreed time limit, I'm prepared to exercise my power under Rule 984A to allow those with the right to speak in this group to do so. And we now move to Group 8, which is the victim's statement, right to make statements other than written statements. I'm calling amendment number 17 in the name of Graham Pearson in a group of its own. Graham Pearson to speak to and move amendment number 17.
The current arrangements in respect of making one's feelings made known to the hearings is that a written statement can be supplied to the board, or alternatively they can be interviewed and give an oral statement to a third party who will then pass on that information for consideration. The amendment, as set out, seeks to offer the right to a victim or nominated person to make an oral representation to be heard first-hand. And there's no doubt that from victims who offered evidence, both to committee and elsewhere, have indicated that they would wish to be able to make an oral representation on behalf of themselves, their victim and family group. I see no reason why such an amendment can't be carried. I think it would be good in terms of allowing victims to be heard and to have impact on the processes that are being considered, and I would hope that members would feel able to support the amendment.
Thank you. Cabinet Secretary.
As I've said before, victims of crime should clearly have the opportunity to communicate to the court the physical, emotional and economic impact of crime. That's why I introduced the Victims' Statement Scheme, which allows victims to give a written statement describing how the offence has affected them. However, as I explained to the Justice Committee last month, I have heard first-hand from victims of crime who have struggled to fully convey in writing the impact a crime has had on them, and who have asked why they cannot submit statements in other formats, for example, a pre-recorded video. That's why I lodged an amendment at stage 2, which was agreed by the Justice Committee, introducing an order-making power into section 14 of the Criminal Justice Scotland Act 2003 to allow the Scottish Ministers to specify the format in which victim statements can be made. Crucially, this will allow alternative formats to be piloted for specific periods of time and in specific areas. Taking a power to pilot new formats will allow for a full evaluation of any new approach to be carried out, taking into consideration the views of victims, the courts, the Crown and the defence. If successful, any new formats of statement could then be extended more widely. In making this amendment at stage 2, my intention was to enable the Scottish Ministers and criminal justice organisations to take a balanced and considered approach to extending the format in which victim statements can be delivered, whilst allowing for the development of new formats in response to advances in technology. Amendment 17, in the name of Graham Pearson, is very similar to an amendment he lodged at stage 2. As I said then, I have concerns regarding the extent of his amendment in that victims would be able to read their victim statement live in court. I'm still doubtful about how well this would work in practice and of the benefits of such a measure, and have concerns about the potential impact on the victim. I note that England and Wales have very recently introduced a new victims code allowing for victims to read their own statements in court, but I am told that it's not yet commenced, and as I said at the time, I'm keen to monitor the progress of this before giving further consideration to such a measure in Scotland. Mr Pearson has also suggested an additional provision enabling the Lord President to issue guidance as to how such representations may be made. It's unclear why it's proposed to confer this power on the Lord President when there is already a power for the High Court to regulate the practice and procedure in criminal proceedings by Section 305 of the Criminal Procedure Scotland Act 1995. Indeed, procedures have been established by Act of a Journal to regulate the submission of child witness notices. It would seem strange for the Lord President to issue guidance on something for which the High Court could produce rules and regulations. Furthermore, the proposed power of the Lord President to issue guidance as to how representations under Section 5AB may be made does not sit easily with the proposal to confer delegated power on the Scottish Ministers under subsection 5AC to prescribe other means of making a statement by order. In light of the existing provisions in the bill conferring powers to pilot new forms of victim statements and the specific concerns regarding any guidance as to how these statements are to be made, I cannot support this amendment. That said, I would not want to rule out the proposal for making oral victim statements altogether, and I reiterate my commitment to Graham Pearson at stage 2, that I would be happy to revisit this issue once greater consideration has been given to how such a measure would operate in practice and the benefits and risks to the victim have been explored in more detail, and on that basis I invite Graham Pearson to withdraw Amendment 17.
Thank you. Can I invite Graham Pearson to briefly wind up and indicate if you intend to press or withdraw?
In good faith and given the assurances from the Cabinet Secretary, I will withdraw.
Is there any objection to that amendment being withdrawn? No. In which case, we move to Group 9, Rights of Children to make victim statements and receive information on offender release. And I call Amendment 32 in the name of Elaine Murray, which is grouped with Amendments 33, 18, 18A and 18B. And I ask Elaine Murray to move Amendment 32 and to speak to all of the amendments in the group.
Thank you, Presiding Officer. Amendments 32 and 33 are similar to ones rejected by the Cabinet Secretary and the Committee at stage 2 and have been reintroduced at the request of Children First, who have issued a briefing supporting this amendment, which has also been supported by a range of other organisations representing children and women, by Barnardo's, the Young People and Children's Commissioner, Scottish Women's Aid, Youth Link and indeed several other organisations, who also were unconvinced by the Cabinet Secretary's arguments at stage 2. The amendments would give the opportunity for a child of under the age of 12 to make a victim statement should the child wish to do so and have sufficient age and maturity. Where a child is not able to do so, a statement may then be made on their behalf by a parent or other qualifying individual. Where a child makes a statement under this section, the child must be provided with whatever support he or she requires in order to be able to do so. And as I say, there is considerable support from a range of organisations supporting this amendment, and I thank all those organisations involved for circulating a separate briefing. The Justice Secretary suggested that we had set the appropriate age of consent for children making a victim statement in their own right at 12. However, criminal investigations and proceedings may involve children as young as 3 giving evidence in their own right, often, I am sorry to say, with not nearly enough support to do so, as victims and witnesses. Surely it is contradictory to only allow children over the age of 12 to give a statement about the impact of crime on them. We could have a situation whereby a young child gives eloquent and compelling evidence as a victim of sexual abuse, which helps to convict an accused, and then is denied the opportunity to tell the sheriff or judge about the impact of that offence on them. Previous legislation acknowledges the importance and indeed the rights of children to make their views known in decisions which affect them. Examples include the Additional Support for Learning Scotland Act 2004 and 2009. There is also precedent for providing children to be supported in doing so. Section 122 of the Children's Hearing Scotland Act 2011 provides for advocacy for all children and young people entering the hearing system. My amendment also seeks to more cleanly define who should make a victim statement on a child's behalf, ensuring that it is those with parental rights and responsibilities who do so, or if the parent or carer is unable to do so, or it is inappropriate for them to do so, to use a qualifying person list to determine who makes a victim statement on behalf of an adult who lacks mental capacity. The definition of this bill of a carer updates that which first featured in the 2003 Act. However, a definition of a carer designed for a specific purpose to distinguish between those who provide unpaid care as family members for a person with support needs in their family and paid carers, and to use that definition in this context is inappropriate. Children can be affected by horrific crimes, both directly and indirectly. They deserve to be allowed to make the court aware of that in their own words and in their own way. And where they need support, whatever their age, they need support to be provided to do so. This amendment would enable a relatively small number of children who have been impacted often by a terrible experience to ensure that the impact of crime on them is heard and listened to by the justice system.
Thank you. I now call the Cabinet Secretary to speak to Amendment 18 and other amendments in the group, please.
Amendments 32 and 33 in the name of Elaine Murray are very similar to the amendment lodged by the member at stage 2, and I do appreciate where Elaine Murray is coming from, and clearly there may be very mature young people who want to make a victim statement but cannot do so. Indeed, at stage 2, I lodged amendments to lower the age at which children can give victim statements from 14 to 12, which the committee supported. However, we tend to take a general view on matters such as the age of consent and the voting age, and I think that a similar approach is appropriate with regard to the age at which victim statements can be made. In addition, if it is felt in the future that children under the age of 12 should be allowed to make victim statements, there are existing order-making powers to enable the Scottish Ministers to reduce the age limit accordingly, and we are more than willing to give further consideration to this in due course. I also have some concerns about the detail of Amendment 33, in that there is no indication of who is to make a decision on whether or not a child is of sufficient age and maturity to make a statement, and who is to provide the support mentioned in subsection 11C. These are clearly matters of some importance, and a lack of clarity on these provisions applied to who would be confusing. Amendment 18 in my name makes a number of amendments to section 16 of the Criminal Justice Scotland Act 2003. That section establishes a system whereby victims can, on request, receive information about the relevant offender known as the Victim Notification Scheme. Most of the changes made by Amendment 18 are required as a consequence of amendments made by Section 19 of the Bill, which repeals certain parts of Section 14 of the 2003 Act, which are in turn referred to in Section 16. These changes simply ensure that the Victim Notification Scheme continues to operate as it does at present. In making this amendment, however, I have also taken the opportunity to lower the age at which children can receive information from the Victim Notification Scheme in their own right, from 14 years to 12 years. At stage 2, the Justice Committee supported my amendments to make a similar change with regard to the making of victim statements. I think it is only right that this age limit will be consistent both with arrangements for making victim statements and with other legislation relating to children, primarily the Age of Legal Capacity Scotland Act 1995, which provides that children over the age of 12 have testamentary capacity and are able to make decisions themselves about many issues. Amendment 18 also provides an order-making power whereby the Scottish Ministers may in future modify the age limits in Section 16 of the 2003 Act independently of the age limits in Section 14 of the 2003 Act. Amendment 18A, in the name of John Finney, seeks to amend my Amendment 18 to introduce an order-making power for Scottish Ministers to be able to change who will be eligible to receive information under Section 16 of the Act through the Victim Notification Scheme. I appreciate the intention behind this amendment, which is to give Scottish Ministers the flexibility to make any further changes if necessary in the future. In light of this, I am happy to support the Amendment 18A. Amendment 18B, in the name of John Finney, would allow the Scottish Ministers to issue guidance on the support that should be available to children if they receive information under Section 16 of the 2003 Act. Again, I appreciate the intention behind this amendment. However, I am not persuaded that there is a need for statutory guidance in relation to such support. And it is not clear who this guidance would be aimed at. I think a better approach would be to work with our justice partners and with victim support groups to identify what support is available currently and how to improve that if necessary. I therefore invite Elaine Murray to withdraw Amendment 32, not to move Amendment 33, and invite members to support Amendments 18 and 18A, and ask John Finney not to move Amendment 18B.
Thank you. And I call John Finney to speak to Amendment 18A and other amendments in the group. Around 2 minutes, please, Mr Finney.
Thank you, Presiding Officer. I'm grateful for the Cabinet Secretary for his support for amendment. However, I've been advised of instances where child victims of very serious offences, such as sexual abuse and domestic abuse, have found out by accident of the release of an offender. Children First, one of the partner agencies the Cabinet Secretary hopefully is working with, and I know is, which works with children to recover from the traumatic experience of abuse, knows of situations where an offender has returned to live in the same community on release, and the child is literally bumped into the offender in the street as the first indication of them being released. What the amendment does not make clear, Amendment 18, is whether, for example, a parent or guardian has the right to be notified if the child victim does not. A child over 12 might simply not want to know or not realise the consequences of not wishing to be notified, but in order to consider how to protect the child from encountering a released offender, the parent or guardian might. How does the amendment provide for such an occurrence? Moreover, a child might not realise the importance of knowing or find the prospect of release traumatic. It is important to allow for the need to provide support for a child victim to address the impact of such information and to process it in as positive a way as possible. Guidance will help the justice authorities work out what might be required in different circumstances. My amendments simply allow for such eventualities, and also for Scottish Ministers, once time is allowed for proper consideration of the effects of Amendment 18, to issue appropriate guidance and to continue to finesse the operation and implementation of Amendment 18 once in place. I hope the Justice Secretary, well, I know the Justice Secretary now has accepted these, and they accept that it's within the overall aims of the bill and is supported by Children First, Amendment 18B, and encourage everyone else to support it too. Thank you.
Thank you very much. And I ask Elaine Murray to briefly wind up and indicate if you intend to press or withdraw Amendment 32.
Briefly, Presiding Officer, Amendments 32 and 33 are supported by Aberlour, Bernardo's, Children First, Clan Child Law Centre, Professor Fiona Raitt, Includum, Janice Scott QC, LGBT Youth Scotland, NSPCC, Parenting Across Scotland, SCC by YP, Scottish Women's Aid, Together, Wave Trust and YouthLink Scotland. So I think I would ask members to listen to them. If you do not listen to me, please listen to them. They are supporting these amendments and I move them.
Thank you very much. The question then is that Amendment 32 be agreed to. Are we all agreed? We are not agreed. There will be a division. Please vote now. The result of the vote on amendment number 32 is yes 35, no 73. There were no abstentions. The amendment is therefore not agreed to. I now call amendment 33 in the name of Elaine Murray, which has already been debated with amendment 32. And I ask Elaine Murray to move or not move.
Moved.
The amendment is moved. The question is therefore that amendment 33 be agreed to. Are we all agreed? Where not agreed, there will be a division. Please vote now. The result of the vote on amendment number 33 is yes 35, no 72. There were no abstentions. The amendment is therefore not agreed. 18. I now call amendment 18 in the name of the Cabinet Secretary, which has already been debated with amendment 32, and I would be grateful if the Cabinet Secretary would move that formally.
Move formally.
Many thanks. I now call amendment 18A in the name of John Finney, which has already been debated with amendment 32, and I ask John Finney to move or not to move.
Move.
Thank you. The question then is that amendment 18A be agreed to. Are we all agreed? Yes. Parliament is agreed. I now call amendment 18B in the name of John Finney, which has already been debated with amendment 32. And I ask John Finney to move or not to move.
Move.
The amendment is moved. The question therefore is that amendment 18B be agreed to. Are we all agreed? Parliament is not agreed. There will be a 30-second division. Please vote now. The result of the vote on amendment number 18B is as follows: yes 48, no 60. There were no abstentions. The amendment is therefore not agreed. That then brings us to the next question, which is that amendment 18 as amended be agreed to. Are we all agreed? Yes. Parliament is agreed. We now turn to Group 10, compensation orders, and I call amendment 19 in the name of Elaine Murray in a group on its own, and I ask Elaine Murray to move and speak to amendment 19 as briefly as possible, please.
Thank you, Presiding Officer. Amendment 19 requires the Court to ascertain the views of the victim prior to making a compensation order and prohibits the making of such an order when the victim has notified the Court that they do not wish to receive compensation from the offender. Victims of sexual offences, for example, may find payment in compensation for the offence perpetrated against them abhorrent. I introduced a similar amendment at stage 2, which the Cabinet Secretary felt might imply that all victims would have to be consulted even if a compensation order was not being considered, and I have worded the amendment slightly in the light of that. MSPs will have received a briefing from Scottish Women's Aid in Rape Crisis yesterday evening supporting this amendment. They believe that as the bill stands, Section 20 has the potential to cause further harm to victims and that compensation orders are not a helpful disposal for domestic and sexual abuse cases. There is no provision in the bill or in the Criminal Procedure Scotland Act 1995 for the views of the victim to be the deciding factor as to whether a court does or does not make a compensation order against the offender. If it is the intention that compensation orders should be considered in every case, the victim must have the right to have their views heard. A compensation order could be a means by which an offender in a domestic or sexual abuse case continues to exert a degree of control over the victim by manipulating or delaying the payment. In many cases, the victim may want no contact with her abuser and certainly will not want money from him. Moreover, a compensation order might be made as an alternative to another disposal, again potentially causing great distress to the victim. And I move Amendment 19.
Many thanks. Very briefly, contribution from Sandra White, please. Could I have Sandra White's microphone, please?
Thank you very much, Presiding Officer. Yeah, I will be very, very brief. I just rise to support Elaine Murray's amendment. I think concur with everything she says. It is abhorrent for women who have suffered sexual abuse, have told us that basically to get a compensation order is abhorrent to them. So I rise to support Elaine Murray's.
Many thanks. And also briefly, Margaret Mitchell.
Yeah, very briefly, the Scottish Conservatives are minded to support that it seems eminently sensible and appropriate that the views of the victims should be sought before a compensation order is sought.
Many thanks. Cabinet Secretary.
As I explained at stage 2, courts may currently consider imposing a compensation order on offender but are under no obligation to do so. Section 20 of the bill is intended to ensure that the court considers imposing compensation orders in relevant cases but does not remove its discretion to decide whether or not this is appropriate. In making such a decision, the court considers all the circumstances of the case and would rightly take into account any views expressed by the victim. As the Justice Committee has discussed at stages 1 and 2, Rape Crisis Scotland and Scottish Women's Aid raised some concerns around compensation orders being imposed in domestic abuse or sexual assault cases where, as Sandra White has just said, victims do not wish to receive such an order. As I've said before, by way of reassurance, the bill will do nothing to preclude the court from using its discretion and will impose compensation orders only where it considers it appropriate to do so. Amendment 19 in the name of Elaine Murray is similar to the amendment she lodged at stage 2. In light of the comments she made about the practicality of that amendment and the potential burden on the court, I welcome the changes she's made to narrow the circumstances in which views must be sought to those situations where the court actually intends to impose a compensation order. As I said at stage 2, I do have some doubts as to whether this amendment is absolutely necessary, but the court already considers all the circumstances when giving a compensation order. I understand it's very rare for compensation orders to be awarded in relation to sexual offence or domestic abuse cases, and it is these cases which are at the heart of rape crises and Scottish Women's Aid's concerns. That being said, I do appreciate the concerns which have been raised, and given the changes made to this proposal since stage 2, I am happy to support Elaine Murray's amendment. Clearly, no one wants to cause further distress to victims, and in those small number of cases where compensation is not wanted, this will ensure it is not granted. We will continue to work with Crown Office and Judicial Office to ensure that this provision works well in practice and to ensure that no delays are caused in the majority of cases where victims are happy to receive compensation. I therefore encourage members to support Amendment 19 in Elaine Murray's name.
Many thanks. Can I ask Elaine Murray to briefly wind up and indicate if you're going to press or withdraw?
Wind up by thanking the Cabinet Secretary for accepting the amendment and for the support of other members in the Chamber, and I move the amendment.
Thank you very much. The question then is that Amendment 19 be agreed to. Are we all agreed? Yes. Parliament is agreed. That brings us to Group 11, Restitution Orders Application of the Fund, and I call Amendment 34 in the name of Alison McInnes, which is grouped with Amendment 35. And I ask Alison McInnes to move Amendment 34 and to speak to both amendments in the group, please.
Thank you very much, Presiding Officer. Amendments 34 and 35 would extend restitution orders and the associated fund to fire and ambulance service personnel. It means that an assault on these workers, and not only on the police, could lead to the offender making a payment to the fund and in turn enable these employees to access the specialist support services that it will provide. Attacks on emergency services personnel are not limited to the police. During stage 2, all parties, including the Cabinet Secretary, were sympathetic to the argument that there ought not to be a distinction. However, concerns were expressed that this proposal could prove impracticable, too difficult to identify suitable beneficiaries, or too expensive to administer. Yet even the Cabinet Secretary acknowledged during stage 2 that benevolent funds exist for the distinct groups of emergency workers to whom I wish to extend restitution orders: the Firefighters Charity and the Ambulance Services Benevolent Fund. It would be for the administrator of the new fund to decide whether they would be appropriate beneficiaries. And Scottish ministers will have the power to make further provision for the administration of the restitution fund. I would therefore maintain that it would be within its gift to ensure that the operator divides and distributes the money in a manner that supports victims of the relevant offence for which it was collected, as would be appropriate in the circumstances. The Law Society supports extending restitution orders to a broader group of workers, and it has been suggested to me that if the number of assaults under Section 1.1 of the Emergency Services is comparatively low, as the Cabinet Secretary argued at stage 2, then the additional administration costs would be minimal and more readily absorbed into those resources necessary for the Restitution Fund in general. And I move Amendment 34.
Many thanks. Briefly, Margaret Mitchell.
Thank you, Presiding Officer. There seems no good reason why restitution orders shouldn't apply to other emergency workers, not just to police alone. And given Alison McKinnon's comments, I'm minded, as the Conservatives, who support these amendments in her name.
Many thanks. Cabinet Secretary.
Well, as I've said before, I am sympathetic to the idea of extending restitution orders to workers other than the police, provided the system would actually work. I acknowledge that Alison McInnes has attempted to extend the scope of restitution orders in such a way as to ensure that for each emergency worker who is a victim of assault, there could be appropriate beneficiaries who could receive payment from the restitution fund. The amendments certainly make the operation of the restitution fund more complex. Payments to the restitution fund would require to be ring-fenced according to the type of offence for which the restitution order was imposed. It would be inappropriate to use monies recovered in respect of an assault on one type of emergency worker to make payments to organisations which provide support to different emergency workers. The Scottish Court Service would therefore be left with the burden of splitting the charges in the 2005 Act into their component categories of worker to ensure the money may be appropriately ring-fenced when it goes into the restitution fund. The operator of the fund would also require to ensure that monies received for certain offences were disbursed to organisations which support victims of those offences. Moreover, the proposed amendments do not address the very obvious practical difficulty I described at Stage 2. In 2012-2013, the figures for which are now available, there were 3,137 persons with a charge proved under Section 41(1)(a) of the Police Scotland Act 1967 and only 139 persons with a charge proved in respect of all emergency workers under Section 1 of the Emergency Workers Scotland Act 2005. The scale is thus completely different. Crucially, this is reflected in the sums that might be available. While sums for assault on the police raise six-figure sums every year, as I said at Stage 2, the Scottish Court Service advises that there were no fines income at all in 2011-12 and 2012-13 from any of the charges in the 2005 Act. Instead, these were dealt with by community payback orders or imprisonment. It's not clear, therefore, that there is any potential income at all for restitution orders for any category of emergency workers. The proposed amendments are therefore likely to result in a burden on the operators of the restitution fund. The income received in respect of assaults on emergency workers under the 2005 Act may well be insufficient to cover the operating expenses incurred by extending the scope of the restitution fund to include them. Rather than providing benefits for the intended recipients, it's quite possible these amendments would result only in a burden on the operators of the restitution fund. Restitution orders would work in respect of assaults on police officers where there is clear evidence the volume of potential income is there. The use of financial penalties will result in real benefits for the provision of support services. The same, unfortunately, cannot be said in respect of other emergency workers, certainly not at the present moment. And in these circumstances, in reflecting upon what I've said, I would urge Alison McInnes to withdraw Amendment 34 and not to move Amendment 35. These matters can be reviewed and revisited in due course, but at the present moment, we would harm those that she seeks to benefit.
Thank you. Alison McInnes to briefly respond and indicate if you're going to press or withdraw.
I've listened to what the Cabinet Secretary says, but it seems perverse and inequitable that only an assault on a police officer and not on a firefighter or a paramedic responding to an emergency should merit a restitution order. And it is unfair that only one segment of our emergency services personnel should have the benefit of the support services that the funds will provide. I will press Amendment 34.
The question then is that Amendment 34 be agreed to. Are we all agreed? No. Parliament is not agreed. There's a division. Please vote now. The result of the vote on amendment number 34 is yes 48, no 57. There were no abstentions. The amendment is therefore not agreed to. I now call amendment 35 in the name of Alison McInnes, which has already been debated with amendment 34. And I invite Alison McInnes to move or not move.
Move.
The member has moved. The question therefore is that amendment 35 be agreed to. Are we all agreed? Parliament is not agreed. There will be a division. This will be a 30-second division. The result of the vote on amendment number 35 is as follows. Yes 47, no 59. There were no abstentions. The amendment is therefore not agreed to. I call amendment 20 in the name of the Cabinet Secretary, which has already been debated with amendment 9, and I ask the Cabinet Secretary to move formally.
Formally moved.
Many thanks. The question is that amendment 20 be agreed to. Are we all agreed? Yes. Parliament is agreed. I now call amendment 21 in the name of Graham Pearson, which has already been debated with amendment 28, and I ask Graham Pearson if you wish to move or not move.
Formally moved.
The amendment has been moved. The question therefore is that amendment 21 be agreed to. Are we all agreed? No. Parliament is not agreed. There will be a division. This is a 30-second division. Please vote now. The result of the vote on amendment number 21 is as follows. Yes 46, no 61. There were no abstentions. The amendment is therefore not agreed. Before I call the next group, can I advise Parliament that as we are nearing the agreed time limit, I am prepared to exercise my power under Rule 9.8.4 AA to allow those with a right to speak in this next group to do so. I now call Group 12, Life Prisoners, Victims' Rights to make oral representations to the convicted person, and I call Amendment 22 in the name of Graham Pearson, which is grouped with Amendment 23, and I ask Graham Pearson to move Amendment 22 and to speak to both amendments in the group, please.
Thank you, Presiding Officer. Amendments 22 and 23 are very similar to an approach that I suggested in an amendment which related to oral representations in court. The evidence that was presented during the processes at Justice Committee indicated that victims and victims' relatives felt disenfranchised by the process of criminal justice and that their voices weren't heard at key moments in that process stage. Amendment 22 indicates that we would give victims the opportunity to make an oral representation to a board considering the release of someone who had previously been sentenced to life imprisonment. And it would be a very discrete number of prisoners that such an amendment would have any impact on. There were considerations offered that to allow victims or their relatives to make such representations would offer difficulties in terms of security in the prison, the pressure that such a representative would have trying to make an oral presentation in such circumstances, and a whole series of technical challenges. But I believe that offering an option to make that representation orally but by closed-circuit television would overcome many of the problems that we might seek here. There was also some difficulty about whether or not the prisoner would be able to hear everything that was being said, and I suggest that the amendment covers that eventuality and should provide the right kind of presentation. As far as Amendments 23, 24, Amendment 23 is consequential in terms of the video link. Amendment 24 relates to Scottish ministers issuing guidance to Scottish Court Service on the minimum standards to apply provision of information in relation to solemn procedure. And in terms of that amendment, it seeks to ensure that those witnesses and victims who go to court in terms of solemn procedure are guaranteed, should they wish access to information, a whole series of information provided to them. We haven't gone into the detail of what that information might be. I think that that would be subject of some discussion. But it's certainly come over from victims that they appear at court without any previous involvement with a court and without ever having the opportunity to visit when it's empty. They've ended up in situations where they feel oppressed by being placed too close to an accused person, and that they've had no understanding of procedures before they enter. And this amendment would give the opportunity for advice to be offered and guidelines to issue a benchmark. I propose the amendments and would seek the Chamber to support them.
Thank you very much. As I indicated, I'm only able under the rules to call those who have a right to speak in this group, and therefore I call the Cabinet Secretary.
Amendments 22 and 23 would allow victims to make representations about release and licence conditions directly to the prisoner via video link. As I said at stage 2, I consider this proposal to be seriously flawed. The prisoner has no involvement in decisions about his release and any licence conditions that may be attached, so there appears to be little purpose in the victim speaking directly to the offender about these matters. Decisions on release and licence conditions are rightly made by the parole board, taking into consideration all the reports on the conduct and progress of the prisoner. For the benefit of those not present at stage 2, I would reiterate that victims in relevant cases are invited to make representations to the parole board about the release and possible licence conditions. The bill is extending this to include oral representations for life sentence prisoners. The prisoner already sees and will continue to see the representations made by the victim unless there is good reason to withhold them from him or her. There is nothing to be added to the effectiveness of the parole process by including these amendments. The primary concern of the parole board is to consider the risk of releasing a prisoner. That risk is best assessed by considering relevant representations by the victim to the parole board alongside all the other reports that have been prepared on the prisoner. In summary, I do not think there would be any benefit to either victims or the parole process in allowing such representations to be made to prisoners, and as I have said before, it may well be counterproductive in giving the victim unrealistic expectations about what could be achieved through such a process. I also have concerns about the effect on the victim of such direct contact, which could be extremely traumatic. I therefore urge Graham Pearson to withdraw Amendment 22 and not to move Amendment 23.
I now call on Mr Pearson to wind up as briefly as possible and indicate if you wish to press or withdraw.
I do wish to press the amendments. I'm disappointed that the Cabinet Secretary has responded in the way that he has. I'm not surprised that he sees little value. The value would be from the point of view of the victim, who has an opportunity to express an impact assessment personally and know that it has been heard by the person that they know as a perpetrator. We spoke earlier about restorative justice. There's no doubt in my mind that if the victim sees value in it and would want to make an oral representation, then the system should be capable of enabling that to happen. I press the amendment.
Many thanks. The question then is that Amendment 22 be agreed to. Are we all agreed? Parliament is not agreed. There will be a 1-minute division. Please vote now. The result of the vote on Amendment 22 is as follows. Yes 46, no 60. There were no abstentions. The amendment is therefore not agreed to. That then brings us to calling Amendment 23 in the name of Graham Pearson, which has already been debated with Amendment 22, and to ask Graham Pearson to move or not to move.
Move, please.
The member has moved the amendment, in which case the question is that Amendment 23 be agreed to. Are we all agreed? We are not agreed. There will be a division of 30 seconds. Please vote now. The result of the vote on amendment number 23 is as follows. Yes 44, no 63. There were no abstentions. The amendment is therefore not agreed to. I now call amendment 24 in the name of Graham Pearson, which has already been debated with amendment 28, and to ask Graham Pearson to move or not to move.
Moved.
The amendment has been moved, in which case the question is that amendment 24 be agreed to. Are we all agreed? Parliament is not agreed. There will be a 30-second division. Please vote now. The result of the vote on amendment number 24 is as follows. Yes 44, no 61. There were no abstentions. The amendment is therefore not agreed, and that ends consideration of amendments. Could I ask members who are leaving the chamber to do so quickly and quietly, please? We now come to the next item of business, which is a debate on motion number 8562 in the name of Kenny MacAskill on the Victims-and-Witnesses Scotland Bill. I invite members who wish to participate in this debate to press the request to speak buttons, and I advise the chamber that we are incredibly tight for time in this debate. I call on Kenny MacAskill to speak to and move the motion. Cabinet Secretary, 10 minutes maximum, please.
I'm pleased to open the debate today on the Victims-and-Witnesses Scotland Bill. Much time is spent talking about the way our criminal justice system works, and rightly so. But in doing so, we must not leave out the discussion the needs of those arguably most affected by it. The victims and witnesses of crime. I'd like to begin by thanking the members and the clerks of both the Justice and Health and Sport committees for their work over the past year. Their scrutiny and discussion of the proposal in the bill has been both detailed and considered, and has resulted in certain aspects of the bill being clarified and enhanced. I also wish to thank those who have been involved in the development of the bill, in particular those organisations and individuals who have responded to the consultation. Victim support organisations such as Victim Support Scotland and Scottish Women's Aid, who gave evidence to the committee and provided robust and constructive feedback throughout the bill process, and to our justice partners. Most importantly, I'd like to express my gratitude and that of the Minister for Public Health to those individuals themselves, victims of crimes and survivors of institutional child abuse, who have shown great strength in sharing their views, knowledge and experiences with us all. The bill contains provisions both to improve support for victims and witnesses and to establish a national confidential forum to receive and listen in confidence to the experiences of adults who were placed in institutional care as children, including experiences of abuse. I'll turn first to the elements of the bill focused on our criminal justice system. The central aim of our proposals is to put victims and witnesses at the heart of our justice system and to improve the information and support available to them. The bill will ensure offenders pay towards the support needed by victims through the introduction of a victim surcharge to be used to help meet the immediate needs of victims of crime. It will make important improvements to the support available for vulnerable witnesses giving evidence, and it will require justice agencies to set and publish standards of service to ensure that victims and witnesses know exactly what to expect when they come into contact with the justice system. These and other proposals will also help ensure that Scotland is compliant with the EU Victims' Rights Directive. Earlier this year, the hosting of the Victim Support Europe Conference here in Edinburgh acknowledged the positive progress made in Scotland in meeting the needs of victims and witnesses. A number of important improvements were made to the bill at Stage 2, many of which responded to suggestions raised during the Justice Committee's Stage 1 scrutiny. In response to concerns raised at Stage 1, Alison McInnes proposed an amendment providing that objections should not be possible in relation to those standard special measures which are automatically available to certain categories of vulnerable witness. I gave my full support to this and believe the provisions on special measures now strike the appropriate balance between the rights of victims and the accused. The Justice Committee suggested a reporting mechanism be introduced to ensure accountability in terms of justice organisations meeting the standards of service which will be required to set out under Section 2. We've introduced such a mechanism, requiring organisations not only to reflect on how they've met the standards during the reporting period, but also to think ahead as to how they intend to meet the standards in the future. And we also introduced a requirement for organisations to consult each other in developing their standards to encourage a consistent and joined-up approach. We introduced a power to pilot alternative formats of victim statements, such as pre-recorded videos in direct response to calls from victims to consider allowing flexibility in how such statements may be given, and I reiterated that commitment today. Furthermore, we introduced an obligation on the Lord Advocate to make and publish rules about the process for reviewing decisions not to prosecute. This will increase transparency in the justice system and reflects the requirements of Article 11 of the EU Directive on Victims' Rights. And I'll now turn to those elements of the bill relating to the establishment of the National Confidential Forum. In 2009, the Scottish Ministers committed to a pilot forum to test out a model for enabling adults who were placed in institutional care as children to describe their experiences, including, sadly, abuse and neglect. The outcome of this was the Time to be Heard pilot forum. Provisions in the bill relating to the NCF are based on this successful pilot. The NCF will give people who were placed in institutional care as children the opportunity to share their experiences through a confidential, supportive and non-judgmental process. The NCF will help improve the health and well-being of such individuals by offering acknowledgement of their experiences, including experiences of abuse and neglect. Lessons may also be learned from these past experiences to help us inform current and future childcare policies. We listen to the views of survivors and stakeholders and welcome the recommendations made by the Health and Sport Committee. At Stage 2, the Minister for Public Health proposed amendments that will enhance the scope of the NCF and give more people an opportunity to participate, all of which receive cross-party support. We've extended the eligibility criteria to include 16 and 17-year-olds. We've clarified the definition of institutional care to ensure that a range of care or health services can be included as being part of the eligibility criteria. We've ensured a balance between an ability for the Mental Welfare Commission and NCF to produce reports while retaining confidentiality. We've also recognised the importance of allowing the NCF to operate as soon as possible, and the bill now provides for appointments process to begin without delay, so that former residents, in particular ill and older survivors, will be given the opportunity to participate in the NCF from 2014. Of course, the bill is not and will not be the end of the process of reform and improvement. Implementation of the proposals relevant to the criminal justice system will be taken forward in the wider context of the Scottish Government's Making Justice Work programme, a central objective of which is to improve the experience of victims and witnesses. We will work closely with our partners in the criminal justice system and the third sector to ensure that the provisions are implemented effectively. We will also continue to work to identify improvements that can be made on a non-legislative basis. For too long, victims have been treated and made to feel like bystanders in the criminal justice system. The passage of this bill will see more consideration given to the rights and needs of victims and witnesses of crime and will improve their experience of the system to which they turn to see justice served. I look forward to hearing members' views on the bill, but I can confirm that this is not just the end of a journey, but perhaps the end of a stage on a journey. But I therefore move that the Parliament agrees that the Victims-and-Witnesses Scotland Bill be passed.
Many thanks. Before I call the next speaker, can I advise Parliament we are very tight for time. I apologise to the two members who won't be able to be called in the debate, and I advise other members that speeches will be of 3 minutes. I also thank the next two opening speakers for cutting their time, and I call on Graham Pearson, maximum of 6 minutes.
Thank you, Presiding Officer. First of all, can I begin by thanking the clerks and colleagues who remain on Justice Committee for the work and the commitment they've shown over the last few months in dealing with this legislation. I think it's also appropriate to thank those who, on behalf of the Parliament, prepared the amendments that we put forward this afternoon and the work that they turned out of such a high quality, in spite of the fact that we were unsuccessful in so many of them. Most of all, I would like to record my thanks to the victims who came forward and shared their experience of the current situation and their experience of a system which operates to deliver justice across Scotland. And there's no doubt that that experience has been a very mixed bag. The approach in terms of this legislation, as I indicated earlier this afternoon, was largely driven a desire to ensure that Scotland fell in step with European directives in relation to matters of victimisation and witnesses. And that's a laudable outcome in itself. What I do think came from that approach was perhaps not quite the focus on the needs of victims and witnesses and the reality of their experience within our system. And to that extent, I'm disappointed at the lack of ambition to actually deliver on some of the needs that these victims and witnesses have expressed to us and have been so willing to share. The ability of services to deliver in uniformity, which the Cabinet Secretary has indicated is such an important matter for the future, I agree with. However, in evidence given to Justice Committee, it was made very clear by witnesses from the police and other services that currently they didn't have the facilities to deliver the kind of information that was required in a format that witnesses and victims would find acceptable. And that's a real worry and concern for the years ahead as we look to see how we do indeed improve the experiences of witnesses. And I would hope that the Cabinet Secretary would remember that evidence and take particular account of the need to ensure that these systems operate effectively within each individual service and across the services in a collaborative way. The impact on witnesses and victims of their experience in court was rehearsed, but certainly I found it very moving to know that what they'd found was that the experience of the crime itself was almost matched in terms of impact, their experience of the court process. And that notion of not understanding what was happening, not understanding the layout of the court, no one explaining the processes that they were to enter into. Even if the Cabinet Secretary would note, and it passed me by in spite of the experience I've had of nearly 4 decades, but for a deceased family to constantly have to iterate the accused name in order to find out information about the case, many victims find that as extremely galling and very painful. And there must be a way that our system is able to adapt and deal with that kind of detail which has such impact and remains with these victims for years thereafter. Equally, the implication of their involvement in the victim notification scheme, it became very apparent that out of the blue to receive an official letter through the post with bureaucratic language and an approach which is necessarily absent of emotion was to take the victim or victim's family right back to the crime again and to leave them at home very often alone to consider their next steps. In one set of circumstances, the widow of the deceased involved in a murder trial was left to make contact as indicated in a letter, and eventually received 6 letters with 5 named contacts and still an absence of information. So as much as we've looked to how do we move forward and develop this brave new world, the Cabinet Secretary needs to understand that the current world that we exist in is far divided from the guidance and the kinds of decisions that have been taken in this Parliament to protect our victims and witnesses. We've spoken a great deal about the emotion and the impact it has on these victims, but in a very selfish sense, this Parliament should be very concerned at the range of victims and witnesses who have suffered through the system. The system cannot work if it doesn't have the confidence of the public to engage. And where they've been victimised and where they've been witnesses in court, it very often leaves them denuded of any confidence as a citizen. It leaves them damaged and less able to come back into the community as a fully fledged citizen, and certainly less engaged to want to become involved again in the future. So all the amendments that have been proposed with a view to improving that situation, to bring a balance between the rights of the accused and the needs of the victims and witnesses in our system. And I hope that the Cabinet Secretary has taken some evidence that we've offered through the afternoon and will take steps to improve again the contents of this bill. Thank you.
Many thanks. And now calling Margaret Mitchell, 4 minutes, please.
Thank you, Deputy Presiding Officer. I welcome the opportunity to speak in this Stage 3 debate on Victims and Witnesses Scotland Bill, which was first published by the Scottish Government as far as February 2012. The bill makes provision for certain rights and support for victims and witnesses. To date, no victim-specific legislation has been passed in the Scottish Parliament, although there have been a number of legislative and non-legislative changes made relating to victims since 1999. So the aim of the bill is to put victims' interests at the heart of ongoing improvements to the justice system and to ensure that witnesses are able to fulfil their public duty effectively. This bill is welcome as a major step towards achieving this aim, and during the scrutiny of the bill I tabled amendments intended to strengthen and improve the legislation. For example, the bill confers a whole range of rights on victims, yet fails to define who a victim is. Consequently, a definition of victim was tabled for clarification, but the Cabinet Secretary was not minded to accept this, despite the Law Society's view that a clear definition will be crucial if the bill is to deliver on its promise to place victims' interests at the heart of ongoing improvements in the Scottish justice system. In addition, all parties accept that more could be done to encourage justice organisations to work collaboratively. But the amendment to put on statute a requirement for the police, the Crown and the court service to work together, and crucially to offer a single point of contact for victims, which was eminently sensible, was also rejected by the Cabinet Secretary. The amendment to introduce independent legal advice for victims of serious sexual assault sought to tackle a long-standing concern about the inappropriate use of complainers' and victims' health and other sensitive information in sexual offence trials. Today we had the opportunity to address this terrible injustice, which only the Cabinet Secretary and his government denies exists, namely the use of this information for the sole purpose of seeking to discredit the victims of rape, attempted rape and other serious offences. My amendment could have tackled this inappropriate use of information and put in place a much-needed pilot which would only have cost a mere £20,000. A few of the white paper adverts and billboards, I suggest, presiding officer, could have paid for that if we had a few less of these. So while the bill will have the support of the Scottish Conservatives this evening, there are clearly glaring omissions in its content, which we can only hope will be rectified in the future.
Many thanks. I turn to the open debate speeches of 3 minutes as indicated, and I call Christine Graham to be followed by John Pentland.
Thank you, Deputy Presiding Officer. First of all, I think in terms of the bill, I'm pleased to recognise that at Section 1, we define, well, it's not so much a definition, but reference to be a victim or one who appears to be a victim. Because we must always remember that until court proceedings are concluded, the person who is the prime witness is an alleged victim at that stage until proven, maybe a victim to the police and to everybody else, but within court is the alleged victim. So that's important. Maintaining that the principle of you're innocent till you're proven guilty, there's a presumption of innocence, the burden of proof is on the Crown, and the standard of proof is beyond reasonable doubt. But I welcome this bill because victims, alleged victims, witnesses, it goes without saying that quite often in court it's mystifying what goes on. And although there has been a cultural change and there have been moves to make it more, can you use the expression, user-friendly, it's not been good enough. I recall myself as a civil practitioner being in the criminal court, not knowing what was going on in the well of the court, to see the Procurator, Fiscal and Defence having a wee chat. The mumblings went on, and presumably it was plea bargaining in the middle of the thing. So goodness knows what the public were to make of it. It's equally important that not only is information given to someone from the start of going to police station to make a complaint about an alleged offence, right through to the release of the convicted person, that it's made in plain English. In here, we're also very guilty of getting into techno-speak, and so very important that somebody understands and they feel they can ask for an explanation of what's going on. I don't think the single point of contact, worthy though it seems to be, is practical. What happens if that single point of contact is ill, on holiday, not available? I think the idea of a hub, if it's developed, is a good idea, but personal touch is always important.
Final minute.
I accept there are as many variations of witnesses as there are of the features on our face. So I find it interesting, the vulnerable witnesses part of it, because some witnesses can be tough cookies. They will know the inside of court like the back of their hand. They know it better than the judge or the sheriff. So you mustn't think that all victims, alleged witnesses are, in fact, little sweet people. But it is important that we protect the majority of people who never thought they'd be in a court, who find themselves in a court giving evidence and find out it's not like it is on the telly. I'm finished. I've done it with time to spare. Thank you, Deputy Presiding Officer.
Many thanks for that. John Pentland to be followed by Roderick Campbell.
Thank you, Presiding Officer. Court proceedings can be stressful at best of times without having to recount in intensive detail not only the crimes of which people are victims or witnesses, but also other information about their lives, past and present, evidence that is sometimes questionable relevance. Of course, the courts need to establish the truth, and not all witnesses and victims tell the whole truth and nothing but the truth. But for the many who do, questioning can seem like an unwarranted intrusion on their private lives and an unjustified attack on their character. Yet while defendants have lawyers to advise them and to give significant support, and the prosecution has extensive resources at their disposal, victims and witnesses are too often left out in the cold. The limited advice and support is available to them, but they lack someone to speak up specifically and solely for their interests in the court proceedings. As the amendments moved by Elaine Murray highlighted, we ought to ensure that our legislation is sensitive to the needs, rights and wishes of child victims and witnesses, and the welfare of the child should be paramount when setting standards of service for child victims and witnesses. And there should also be guidance on the circumstances in which sensitive personal information of victims of sexual offences can be disclosed in court, and legal advice made available to victims in such circumstances. The victims and witnesses should be consulted before changing regulations that affect them, and victims should be able to choose how they are told about the prisoner's eligibility for release and the outcome, and to get the support coping with the news rather than the shock that can result from a letter landing on the doormat. We should also give victims and witnesses, if they wish, to speak directly to the offender via video link ahead of release, at least in cases of life imprisonment. Now, we welcome this bill, but we also regret that it had become a missed opportunity. Now, even though the Cabinet Secretary today has accepted one of Labour's amendments, it could have been so much better if the Cabinet Secretary and his committee colleagues at Stage 2 had been more willing to accept suggestions from other parties, often based on the wishes and suggestions for improvements made by victims and organisations representing children and young people. But that said, after 6.5 years of government, finally we have legislation that, while not as ambitious, it could have been and still an improvement. So it's on that basis, Presiding Officer, despite the reservations, I will support it.
Many thanks. Roderick Campbell, to be followed by Alison McInnes.
Thank you, Presiding Officer. May I refer to the Declaration of Interest as a member of the Faculty of Advocates? It seems a long while ago since we embarked on scrutiny of this bill, which responds to a very real need to improve the lot of victims and witnesses in the criminal justice system. At the end of the day, we need to recognise that the impact of crime itself is deeply stressful without the justice system compounding that. So this bill serves a useful purpose and not only is it taking account of the EU directive, but certainly goes beyond that. In the short time available, I'd just like to make a few other points. More information for victims is a must. They can't understand the process if they do not have that information. This bill is certainly a step forward in that respect, with the caveat that any online hub should not replace the human touch, that vital face-to-face support that victims need at a very stressful time. Decisions not to prosecute. Since Stage 1, we've had a Crown Office review, perhaps encouraged by the European Directive, giving rise to the amendment introduced at Stage 2, which enables a victim to request a review with the obligation on the Lord Advocate to set and publish procedural rules for conducting a review. That's a step forward, but it would certainly be helpful if the Government could advise on the timetable for the publication of such rules. 3. Automatic special measures. At Stage 1, there were concerns that extending the right to extend special measures was in conflict with allowing a right to object. And at Stage 2, we sought to differentiate between standard special measures and non-standard special measures, preserving a right to object to the latter. That strikes me as the right balance. Victim surcharge. The Cabinet Secretary has outlined an approach that might be described as testing the waters, applying first only to cases that result in a fine. That seems sensible to me, to give the Government flexibility to respond to changing circumstances and to learn by experience. But one thing which I think also needs time for consideration is the interaction between victim surcharge orders and compensation and restitution orders. Legal advice for victims in relation to sexual offences. We debated this earlier, and at Stage 2, the Government's view was that it would result in a major innovation in the law with wide implications. I accept that, and of course Parliament rejected amendments today. But I cannot but think that this is an issue which will certainly re-emerge in the future, and I think might benefit from up-to-date research and inquiry. Presiding Officer, in conclusion, this bill is an important addition to the changing framework of justice in Scotland and will hopefully provide support for victims and witnesses while balancing the rights of the accused to a fair trial. The aim must be to improve the experience of those who, through no fault of their own, are involved in a system which may seem overwhelming, a system in respect to which David McKenna of Victim Support Scotland said in evidence that, quote, "There is a widespread sense that the justice system does not provide recognition of the individual's experience and does not demonstrate respect or treat the individual with dignity. That, Presiding Officer, needs to be a thing of the past." Thank you.
Many thanks. Alison McInnes, to be followed by Duncan McNeill.
Thank you, Presiding Officer. It is important to remember that crimes are not simply statistics. Behind every one there is a victim whom we have a responsibility to protect. And while we've been fortunate in Scotland to have a system of support for victims and witnesses, it has become absolutely crystal clear during the passage of this bill that there is much more to be done to ensure victims are treated with dignity, respect and given proper support and protection. The passing of the bill today will enhance the rights of victims of crime and of those who witness such harm. And in addition, the National Confidential Forum addresses the needs of those who have suffered historic abuse. Quite rightly, much of the focus throughout the bill's passage has been on delivering improvements for the most vulnerable in our society. And at Stage 1, there was dismay among victims and those who speak for them about the proposal to allow objections to the use of standard special measures, existing safeguards which allowed children and vulnerable witnesses to give evidence without appearing in the courtroom. Victims' organisations argued that this proposal would undermine all the other provisions and rights contained in the bill, which was a pretty damning verdict. I was therefore pleased to secure an amendment at Stage 2 that means these individuals' rights will not be eroded, and I am grateful to the Cabinet Secretary for his support on that matter. Given that the bill seeks to ensure that the system works better for victims and that Scotland complies with the relevant EU directive, I did consider the initial omission of restorative justice significant. And again, I've been pleased to be able to table an amendment to this effect and grateful to the Cabinet Secretary for his support at stage 3. Over the years, Parliament has increasingly recognised that restorative justice services can, in the right circumstances, assist victims to overcome their experience, achieve a greater understanding of why they were a victim and have an opportunity to receive a genuine apology. And in turn, it can also inspire those who have caused harm to reflect on their actions and take personal responsibility. We know there are some excellent restorative justice services already operating, but I also believe these services have too often developed in a piecemeal fashion. I hope the inclusion of this section in the bill will highlight their value and instill a greater consistency in the system. Turning to restitution orders, I believe that had the government set its mind to it, it could have extended the system to include the fire and ambulance service personnel, and I'm disappointed that it did not endeavour to do so. It is a greater disappointment to me and to many others in the Chamber today that the government did not take the opportunity to give added protection to victims of sexual offences by supporting either Graham Pearson's or Margaret Mitchell's amendments, and I believe that that remains unfinished business. No one chooses to be a victim or a witness of crime, and it's therefore incumbent upon us to ensure that they are heard and to seek to make the whole process from the moment a crime is first reported to the point where an offender completes their sentence less intimidating and less distressing. This bill represents a welcome step in the right direction and we will support it today.
Many thanks. Duncan McNeill.
Thank you. Trusters, such as the plea presiding officer to adult survivors of sexual and physical abuse. Trusters, this is what we ask of them to participate in the National Confidential Forum. Trusters. But trust is the most fragile of emotions, hard-earned, easily lost and difficult to win back. Survivors have heard it all before, of course. Trust was taken from them as children in the most traumatic of circumstances. And they have heard it since, with promises of psychological support and judicial action, promises not always kept. This is not a political point, far from it. If we listen to petitioners Helen Holland and Chris Daly. Helen Holland spoke of fellow survivors who had passed away in recent years. She said, "The people who died were denied the right to have their voice heard. Please do not deny people that right any longer." Chris Daly talked about the re-traumatisation. He said survivors have been making this point for years. We have been telling Parliament and the Government that survivors need psychological help now. The Health and Sport Committee welcomes the aims of the National Confidential Forum. It was this aspect of the bill we were asked to consider. We were in support of the Scottish Government's Stage 2 amendments, including lowering the age criteria. But some points from our Stage 1 report are still to be addressed. We would welcome an update on progress of the National Confidential Forum guidance for care providers. We would appreciate a sense of when the findings of the foster care research will be implemented, and we would seek a protection of training needs for those supporting participation at the forum. As one witness said, survivors will judge the success of the forum on the basis of outcomes for them. They will also want, in their testimony, to help children of care today. And we should remember the 300 children who are reported to the Children Panel every year, directly or indirectly affected by sexual abuse.
Final minute.
We need to remember 9 years ago this month, Jack McConnell said sorry to adult survivors on behalf of the people of Scotland. He delivered that apology in this chamber, and I quote, "To those who were subjected to abuse and neglect and who did not receive the level of love and care and support they deserved and who have coped with that burden all of their lives." This is a moral imperative here, Presiding Officer. We must lighten that burden. We must allow those troubles to be heard. We must regain that trust via justice measures as well as healing. And we must support all survivors, whether they choose the forum or other remedies. And in the words of the former First Minister, we must do more to support them in the future than we have done in the past. Thank you.
Many thanks. Thanks to members for curtailing their speeches, and my apologies to Sandra White and John Finney for being unable to call them. We now turn to closing speeches. I call on Margaret Mitchell. Maximum 4 minutes, please.
Deputy Presiding Officer, as I said in my opening remarks, this legislation contains some important measures which will help those affected by crime. Consequently, the Scottish Conservatives will be voting in favour of the bill this evening. However, it's important to point out that the bill was not met with complete support from victims' organisations. The Scottish Government should therefore reflect on the words of Peter Morris, a campaigner for victims' rights, who in his written evidence to the Justice Committee stated, "To say that this legislation is radical is not true, and to say that this now puts victims at the heart of the justice system is also not true. In other words, more can be done, and I hope that this bill is not the end of the process, for there are areas of this bill which could and should have gone further. And the real travesty here is the lack of political will from the Scottish Government to stop medical records and sensitive information being used in a way to discredit witnesses and to play to the prejudices and myths known to persist in sexual offence trials. My amendment could have tackled the appropriate and deeply damaging use of this information. So we now have a situation where Scottish Women's Aid, Engenders, Scotland Against Action Against Stalking, Children First and other organisations support the proposed amendment and the pilot and have offered help to try and make it work. Only the Cabinet Secretary and the Scottish Government have set their face against it. Finally, Presiding Officer, the Scottish Government's effort in this bill to improve the lot of victims, despite the Scottish Government's effort in this bill to improve the lot of victims, the elephant in the room is this. Even if a victim is much better and more swiftly informed about the process, gives evidence in a safer and more protected environment, and then a conviction is secured and they're even able to make a statement before sentencing, all of that is cold comfort to victims if the prison sentence imposed is nothing like the prison sentence served. Automatic early release for prisoners does a disservice to the victim. It discredits the system and destroys public confidence, and the Scottish Government's plans to tackle this disgrace will in effect continue to allow 98% of offenders to be released early with no questions asked. Presiding Officer, this bill is welcome, but my closing remarks puts the limits of its effectiveness well and truly in context.
Many thanks. I now call on Elaine Murray. 6 minutes, please.
Thank you, Presiding Officer. Well, like other parties, Scottish Labour will be supporting the bill at decision time in a few minutes' time. We do believe that the bill will make a positive difference to the experience of victims and witnesses during criminal investigations and proceedings, although, like others, we believe it could have gone further. But I am pleased that my amendment number 19, enabling victims to object to the awarding of compensation orders, was accepted. The Justice Secretary said he didn't feel that it was absolutely necessary. However, others, such as the Scottish Women's Aid and Rape Crisis, felt that the bill, as it stood, could actually make matters worse for victims. So I'm therefore very pleased that Parliament unanimously accepted their view and approved the amendment. I also welcome the reassurances given to my colleague Graham Pearson on his Amendment 17 regarding the rights of victims to make statements in other than written form. I'm sure that attention will be paid to how this reassurance is reflected in practice and the experience of victims in that regard. But the reassurance now is on the record and therefore available to victims and their representatives, and that is always helpful. However, like others, I have been disappointed that other amendments which received support and indeed were actually proposed by organisations representing victims and witnesses were not accepted by the Cabinet Secretary or by Parliament. The bill, as it will be passed, does not recognise the rights, needs and wishes of child victims and witnesses in particular. The justice system, as I said earlier, has been constructed by adults for adults. Both investigation and the court processes can be confusing and frightening even for adults, and how much more so for children. Assurances, of course, again are on the record, which may assist those working with children in these circumstances. But can these guarantee that some of the practices that we hear about that have been endured by children no longer persist? Children First, for example, have advised us of the failures to keep children informed of progress, to make sure that they understand the process and the procedures they're going to go through, or that they're communicated with in forms and methods which they actually understand. We hear about, for example, police calling at school to talk to a young man about the court process he is going to go through, so that his schoolmates hear that it's made publicly available what's happened to him, rather than that being taken at its place and a time where he wanted to. He didn't necessarily want everybody else to know the ordeal he was going through. Children's rights need to be respected, their wishes need to be respected, and that doesn't happen often enough. We do not come up to scratch on that. We are disappointed too that amendments improving the provision of information and support for victims and witnesses were not accepted, as both my colleague Graham Pearson and Margaret Mitchell have already said. And Graham Pearson described a number of personal issues about real experiences of victims who have been let down by the system, victims who have had to continue to repeat their experiences to a variety of different people, who have had where there have been failures in information being passed back to them about what's happening in court, what's happening in terms of... we've all heard that. I'm sure that it's not an MSP who has served for any period of time who has not heard these experiences of victims at first hand. Amendments protecting the victims of sexual crimes for having their medical and sexual crimes revealed to the public in court, unfortunately, were also rejected, and I'm sorry that that happened. And in particular, even if there was a problem in detailing a pilot on the face of the bill, surely the Justice Secretary could have offered to run a pilot without it being in regulation. Surely that could have been the response that the government made to these suggestions, but it was not. As Margaret Mitchell has pointed out, this would have cost very little in comparison to the amounts of public money currently being used to argue one side of the independence referendum debate. The Stage 2 amendments on access to restorative justice seem to me to have been watered down. However, I understand that concerns had been expressed by organisations representing the victims of domestic and sexual abuse, and I hope that the watering down of that amendment today does not actually signal any retraction from the purpose of the amendment, which I very strongly supported at Stage 2. I'm sorry too that the amendment enabling children below the age of 12 to be allowed to make a victim statement was rejected, despite the long list of well-respected individuals and organisations which supported it. As my colleague John Penland has said in his contribution, the government seems to be reluctant to accept amendments offered by members of opposition parties, even when these have attracted widespread support from representative organisations. It feels a little bit like either our faces or our politics don't fit when it comes to some of these amendments. But I feel Duncan McNeill made an important point about the experiences of adult survivors of sexual abuse and the disappointments that they have encountered over the years. This really must not continue, and I echo his request for updates on progress. The Justice Secretary said in his opening remarks that this was the end of a stage of a journey and not the end of the journey. I do agree with that. In our opinion, this bill is unfinished business. Labour members hope and indeed intend to return to the issues which were rejected today. We also intend to monitor how this bill works in practice, and we hope in future to have the opportunity to make subsequent improvements.
I now call on Ken McCaskill to wind up the debate. Cabinet Secretary, till 5 o'clock, please.
Thank you, Presiding Officer. Can I first of all start by thanking Duncan McNeill for his contribution. Understandably, the amendments and indeed the debate throughout has concentrated on the victim and witnesses part, but I think we would be doing the nation a disservice if we didn't record the important part that the National Confidential Forum plays in this bill, and I think him putting it in a historical context was important, to go back to the apology that many of us who were around at that time was made by the then First Minister Jack McConnell. There was a historic wrong. This will not be able to resolve what happened to those individuals, but it's the start of a process which will hopefully help them. My colleague, the Minister for Public Health, has been dealing with that matter, and I am extremely grateful for the work carried out by Duncan McNeill and his colleagues. And I do think that putting on record the background does, as I say, all of us a great service. I can clarify on two particular matters he raised. He asked about good practice, and I can say that the guidance for service is in preparation, and it will be available by the summer of 2014. And with regard to foster care, the results of the survey of those who were in foster care and their interests in the National Confidential Forum have been communicated, I think, only yesterday, so it might be that it is in the post forum. So, as I say, I hope that clarifies matters for him, and I am, I think, grateful for what he has done in putting on record the progress that will be made by the National Confidential Forum. These are ongoing matters. As with regard to comments made just a few minutes ago by Elaine Murray, I think it would also be fair to say that it's unfinished business with regard to those who have been the victims of institutional abuse. And this, as I say, welcome progress, and I'm grateful to all those involved in that. I'm also grateful to all those involved, not just, as I say, in the Chamber today, although there has been some disappointment expressed by colleagues in other parties, and I'll comment on that. I think in the main there is a recognition and a welcome that we are making progress, although I do accept, as Elaine Murray said earlier, that it is work in progress. But let's remember, this is the first ever Victims and Witnesses Bill. It's the first ever in the Scottish Parliament. It's the first ever that has been enshrined to deal with victims and witnesses in Scotland. So I think we should put that on record and recognise the progress that has been made. There are particular aspects that we do have to consider, and we will come back to and address. I've made it quite clear that I don't think that putting a pilot on the face of primary legislation is the correct way to go. I did meet with Rape Crisis Scotland and encouraged them to meet with the Scottish Legal Aid Board. They have done so. There are options there about aspects, whether it could be a women's law centre, whether it could be a change in how we address matters. I'm open to doing that. I saw the letter and the communication about the Legal Services Agency. I know them well. I was a director for several years. I'm happy to consider their proposals, but I do think we have to take some cold light of day to look at matters and to work out what is best. But I'm happy to give that commitment. By all means.
Margaret Mitchell.
A pilot outside the provisions of the bill now.
Cabinet Secretary.
What we have to do is to look at what will provide best for victims and witnesses, to what will provide best for those, especially the ones that are being dealt with by Rape Crisis Scotland. That may be a pilot. It may be a scheme that's been discussed between them and the Scottish Legal Aid Board. It may be something that none of us have yet thought of. What I am committed to doing is to recognise that more has to be done, more will be done. How that will be done, I think, should be worked out with them. And as I say, that's a matter and a commitment I'm happy to give. Same with all oral statements that Mr Pearson has correctly raised. Let's see how they operate down south. They haven't even commenced down there. I'm happy to indicate that that's a matter that we will keep under review as to whether it is progressing and working well. Equally, the same applies to the ages of children. We've gone for the age of 12 because that is when there's testamentary capacity and indeed other aspects that relate to how children are viewed. Our view is that if that is to change, then we can address that in years to come. But again, as with the commitment I've given to Elaine Murray, I think we should recognise that it is work in progress. We have reached the end of a stage of the journey, but I think it's a significant stage for the first time ever to enshrine in law the rights of victims, to ensure that we also cover those who are witnesses, which can be a deeply distressing aspect for many individuals, to make sure that those who are the offenders should contribute and pay to alleviate the suffering and distress, to make sure that we address, as Duncan McNeill said, the issue of those who have suffered institutional abuse. I would also like to take the opportunity to put on record thanks to somebody who's not in the chamber, and that's to the former Lord Advocate Dame Eilish Angelini, because a great deal, if not all the credit for the genesis of this bill goes down to Dame Eilish Angelini. She, I think, correctly recognised during her jurisdiction that actually predated her serving the administration in which I have served, but a previous administration for the Labour and Liberal Democrat parties. She recognised that there was insufficient progress made and that there was a wrong that has to be addressed, and I pay tribute and great credit to her. Equally, I give credit to the Lord Advocate currently serving Frank Mulholland, because he recognised that it wasn't just victims but witnesses, and I said in many instances it can be deeply traumatic to be a witness. There can be instances, sadly, where people can be subject to abuse, harassment or even threats, and we try to recognise that. But we have come a long way. I can give members in the opposition parties the assurance that we will keep the particular aspects under review. But I can say, in reminiscing about when I first entered into law over 30-odd years ago, when I went in there, there was a hierarchy. It was the judiciary that were, first of all, looked after. They dictated how matters would be dealt with in the court. Thereafter, in the pecking order, there was the prosecution, then there was the defence, then there was probably expert witnesses. Nobody considered victims. At best, you might consider whether there should be the provision of a WRVS canteen so they might be able to get a cup of coffee. Sometimes that was provided. In many courts, it wasn't. As for those who were witnesses, they should just like it or lump it. They were expected to turn up, whether they were civilian or whether they were police, whether they were threatened or intimidated. To be fair, good work was done by police, prosecution, indeed Sheriff Clerks to alleviate matters. But there was no consideration, thought or planning aforesaid to try and make sure that that matter was addressed. So, as I say, despite some begrudging comments from some in the opposition benches, I would like to put on record we do now have that historic first. We have enshrined the rights of victims and witnesses. That is long overdue, and we should pay tribute to those that were the genesis, in particular the current and past Lord Advocates. There is work to be done. I am happy to work with opposition parties and indeed with the organisations and agencies that they were mentioning in terms of how we address matters. Although I would have to say to Margaret Mitchell that if she really wants to address some of the difficulties for those who have suffered from rape and sexual abuse, just maybe she should reconsider where she's heading in terms of the removal of the requirement for corroboration, because post-CADR the difficulty is significant, and that is why maybe she should read what Scottish Women's Aid are saying, what Rape Crisis Scotland are saying, what Victims Support Scotland are saying, who are all united in the desire that action should be taken. But we have reached a historic juncture, Presiding Officer. We have enshrined in statute the rights of victims. We do know the standards that they are entitled to expect. We do know the standards that agencies are expected to achieve, and we also know that the offender will pay. I am delighted to be able to have moved the Victims and Witnesses Bill. This is work in progress, but work that we can be proud of.
That concludes the debate on the Victims and Witnesses Scotland Bill. We move to decision time. There is one question to be put as a result of today's business. The question is that motion number 8562, in the name of Kenny McCaskill, on the Victims and Witnesses Scotland Bill be agreed to. Are we all agreed? Yes. The motion is therefore agreed to, and the Victims and Witnesses Scotland Bill is passed. That concludes decision time. I now close this meeting.